I would like to have the permission of SG so that RWPC can have a short meeting after this session this evening to introduce ourselves because the committee is new. We have just been re-elected, and the agenda of the meeting will be circulated in the group during the course of the day. Thank you.
Do you have any comment, SG? Okay. Point taken. You want to have a short meeting after our session with the SG. Thank you so much. Point taken. Yeah, Madam SG, maybe you have something.
Thank you. The meeting is for the Regional Women's Parliamentary Caucus. They should remain behind after the meeting so that they can meet each other, meet the new leadership, and discuss their work plan after the session, not here. So I think the committee secretary will write in the group for RWPC for them to be able to, yeah.
Thank you so much. The request or notice is to all members of the Regional Women Parliamentary Caucus. After we finish our validation session, all members are being requested to stay behind just for a brief meeting from the chair. I think that's the request. Thank you so much, Chair. Any other burning issues, general issues before we start our session? So far, no. Then let's proceed. Dr. Greenberg, let's move on from where we left yesterday. Over to you, sir.
Good morning to you, Mr. Moderator. Good morning to honourable members and other distinguished delegates. Part 9 of the model law deals with procurement and use of public resources. Many jurisdictions will, of course, already have rules about procurement in place. Procurement is also, of course, of particular significance in relation to illicit financial flows. Part 9 will therefore require contextualization during the domestication transposition process to reflect existing procurement laws of individual jurisdictions, and those that have procurement law codes will benchmark those codes against the provisions of the model law to ensure that they are aligned. The procurement activities are defined in the opening clause 97 in a reasonably wide way. Clause 98 introduces a procurement principle that expressly encodes into law the notion that a lowest quote is not always the value for money quote, but an audit trail requires to be kept to show that the procurement activities are carried out in a way that is designed to achieve maximum value for public expenditure. The government departments and other public bodies are required by clause 99 to act in accordance with the procurement principle. And this, honourable and distinguished members and delegates will notice, is a higher threshold in administrative law terms than the have regard to principle applied to some of the values and objectives in the earlier parts of the bill. And that is because it is realistic to expect administrative law standard compliance with the principle articulated in clause 98. At the express request of the technical working group, clause 100.
Dr. Greenberg, pardon me. We have a problem with interpretation. Kindly give us a moment.
I just read Josephine, I cannot hear on the Portuguese channel. Yes, we can hear you now. We can hear you now. Thank you. Can you repeat something again? Yes, we can hear you, ma'am. Josephine, can you? Yes. I kindly speak Portuguese. Thank you.
Thank you. May we proceed? Sorry for that, Dr. Greenberg. Tutube.
How much of what I said before do I need to reprise as a result of that non-translation?
3 steps back, if you allow.
No, I couldn't hear that, sorry.
Maybe kindly just start with the procurement chapter.
Okay. Part 9 deals with procurement and use of public resources. It defines procurement activities in clause 97 in a broad way. Many jurisdictions will have their own procurement code already, in which case they will contextualize Part 9 and use it as a benchmark to assess the fitness for purpose of their existing procurement code. Clause 98 establishes a procurement principle and expressly acknowledges that in subsection 3, that the cheapest quote is not always the best value for money quote, and the requirement is to maximize the value for public expenditure. Clause 99 requires that principle to be applied, excuse me, by public authorities involved in procurement activities. And I draw the attention of honourable members and distinguished delegates to the fact that clause 99 requires compliance. It requires acting in accordance with the principle and not merely taking it into account, as is the case for some of the other values earlier in the bill, because this is an area where it is reasonable to apply an administrative law enforceable duty to obtain maximum value for public expenditure. At the express request of the technical working group, clause 100 exempts government to government assistance from the procurement regulations. That does not, of course, mean that the procurement principle cannot be applied, but it means that the technical rules relating to in-country acquisition are not applicable to relationships between governments. Clause 101 requires the details of the regulatory system to be set out in subordinate legislation. This is standard practice and enables the provisions to be adapted relatively easily from time to time, subject to parliamentary oversight of the regulations in order to take account of emerging commercial developments. Clause 102 extends the principle to the use of public resources, again, not limited to cash. This is a resource-based principle. At the express request of two consultative bodies during the consultative forums, clause 103 requires the use of a modern contract management system designed to facilitate compliance with procurement principles, and clause 104 requires a system for the avoidance and identification of conflicts of interest and their reports. In keeping with the emphasis on combining flexibility with certainty, clause 105 acknowledges that emergency procurement may need to apply different rules. It may need to disapply some of the safeguards on a temporary basis. But again, as with Environment yesterday and retention accounts, the idea is not simply to relax altogether the system and abandon the system, but to acknowledge that the system may be required to be modified in emergency, but nevertheless remains active. Those are the provisions of Part 9.
Thank you, Doctor. He has made presentation on two parts so far, Part 8 and Part 9. And he's actually requesting for interventions from members, if any. Lesotho, Zimbabwe, and Eswatini so far. Lesotho, Zimbabwe, Eswatini so far, in that order. Remember your name and the country is already known.
Thank you very much for the opportunity. Good morning, Doctor, and good morning, honorable members. My name is Honorable Tshepang Tshita Mosena from the Kingdom of Lesotho. I'm making reference to 101 on procurement regulations. Having looked at this section, one could assume that on subsection 2, when the minister takes steps in order to be satisfied that procurement regulations are consistent with those three areas, one may assume that those three elements included are detailed enough and incorporate all the necessary aspects. The question is, procurement is one space where corruption is very highly likely. And if not well controlled, and maybe even the information made public enough for everybody to consume, then there's a lot of detail that goes behind the scenes. And that is where misuse of public funds take place. So the question is, would we consider that one of the three, either public financial management principles or procurement principle or the internationally accepted best practices include publication of results when procurement is made by government? And if that's not explicitly inherent, it could be this spot where we might want to include the publication, because that is where we get to see how the allocation of resources are made vis-a-vis the suppliers to government. And we might want to take keen interest on the allocation of procurement budget for women, for youth, for people with disability, different groups, because that is where you see that people who are rich get richer and the poor get poorer. I submit. Thank you.
Thank you. Zimbabwe? Your name?
Thank you. Let me begin by thanking the talk in the presentation on clauses 98 and 99. You realize that most of the IFFs occur during procurement processes, and the tenders are flouted and the funds are actually allocated to supply in government departments when they are not even supplying the best. Of course, the doctor mentions that the cheapest may not be the best, but also even the most expensive may not be the best. So this provision actually ensures that you get the best, the value for money in terms of determination. And also this provision makes it easy for the Auditor General when they go through the reports to actually determine on whether proper procedure was followed. In the case for Zimbabwe, actually, we have what we call Procurement Regulatory Authority of Zimbabwe, which is a body that then ensures the proper procedure has been followed. So in this, I want to actually congratulate the doctor in the two provisions, because what then alludes to is that it promotes transparency and accountability, and it makes it easy to determine on whether the procedure was actually flouted. Thank you.
Thank you. Now, Eswatini?
Thank you very much, Mr. Moderator, and thank you so much, our esteemed presenter. You'll excuse me in case I'm not orderly in the question I am asking or making comment on.
I'm sorry to interrupt. The sound is very weak at my end. From all speakers, could the technicians please increase the volume at your end? I'm sorry to interrupt.
Yeah, proceed, honorable member from Swatini.
Thank you. I hope I was audible enough to put my case, my point, my comment across. And I'm saying, you'll excuse me in case once more I'm jumping to something.
Apologies, Honorable Senator. Angola has lost the interpreter.
Oh, okay.
Angola,
Is it okay, Angola now?
Yes, yes.
Yeah, it's okay. Okay, proceed, honorable member. Angola is fine now.
Thank you very much. Thank you so much. It's just a comment, an observation which we could share, and maybe our legal drafter could enlighten the House, given our experiences in our various national jurisdictions. For instance, I might be wrong, it's just an observation that the model law so far, having gone through it and having been introduced to it, seems, in my view, when it comes to the powers of the executive, in particular with reference to maladministration, misuse, or financial misconduct. They are the alpha and omega, they being the executive with its support auxiliary services. I was just wondering if or should I say where the normal conventional structures of dealing with criminal issues come in here. I'm not talking as a naysayer, as I say, devil advocate, but where is that structure or those structures that we know come in? Are these just the executive with its auxiliary support staff services, the beginning and the end, so to speak? Maybe I don't know whether we have reached this far. 119, clause 119 talks of it's clause 192. It says it will be a defense for a person charged with an offense under this section in respect of the provision of the Act. No, I think I'm mistaken. Where it's somewhere it says, if you're doing it, if you are charged, and it will be your defense to prove that you didn't have the necessary mens rea, the necessary intention to commit that misconduct. And I think it says it will. It should. I'm just wondering. If
it's 1192. That's right. When we get to part 11, I will address that specifically, although I'll do that now if you prefer.
Thank you. And then we can reserve it until we come there. But
yeah.
Thank you.
Thank you. Are there any additional interventions before we ask the? Yes, Angola, and then Zimbabwe again, Mozambique, then South Africa.
Muito obrigada, senhor moderador. Eu chamo-me Ruth Mendes e sou da delegação de Angola, como já fez referência. Não, eu queria só fazer algumas notas. Primeiro, felicitar o nosso técnico, portanto, o doutor Greenberg, pela forma como está a tratar essa questão aqui. Eu gostaria de dizer que nós, devido aos problemas que fomos tendo, aprovamos recentemente uma lei da contratação pública e muitas das disposições que estão aqui apresentadas nesse capítulo sobre aquisição e utilização de recursos públicos constam da nossa lei, que é uma lei moderna, é uma lei que, de facto, permite que haja transparência, é uma lei que permite que os recursos públicos não sejam desviados da forma como os gestores públicos bem entendem, até porque é uma lei que foi feita com apoio de técnicos do Banco Mundial e do Fundo Monetário Internacional. Portanto, eu quero, de facto, neste capítulo, felicitar a coincidência que há nas disposições que a lei da contratação pública angolana tem e aquilo que está aqui a ser apresentado como sendo uma forma de permitir a transparência, a improbidade e também evitar que os recursos que são para as despesas do Estado não sejam desviados por pessoas individuais. Era, portanto, esta. Muito obrigada.
Thank you, Zimbabwe. Again. Zimbabwe? You use the mic. Use the mic.
Thank you, moderator. And I also want to thank the doctor. My contribution relates to the part 9, procurement and the use of public resources. It is clear that the consultant has done justice to the section, but can learn from other areas such as Zimbabwe, who have set up a procurement regulatory authority to monitor all procurement process. The main advantage of this arrangement is that procurement becomes standardized and the tendencies of fraud and under and over invoicing are also curtailed. These committees are also decentralized to ministries, departments, and units where they receive and evaluate procurement reports to ensure that no procurement procedures have been violated. My second contribution is a point that relates to the use of he in the document. Wherever possible, the proposed model law can or should use he/she as a standard measure, recognizing gender parity and equity. I thank you.
Thank you. I hope the doctor got it. Then next is Mozambique.
Obrigado, bom dia a todos. Meu nome é Carlos Moreira Vasco, deputado da Assembleia da República de Moçambique. Sendo minha primeira vez a intervir, gostaria de saudar, em primeiro lugar, o redator pela apresentação que tem estado a fazer desde ontem e que todos nós estamos empenhados no debate, na discussão sobre esta matéria tão importante, tanto que é a proposta de lei, modelo sobre finanças públicas. É nosso sentimento que esta lei vem a calhar, é pertinente, é oportuna e responde àquilo que são os anseios, as preocupações prementes do nosso país e também do nosso Parlamento, tanto no âmbito da necessidade de integridade, imparcialidade, profissionalismo e tanto capacidade de resposta às preocupações que são pertinentes, que são levantadas em cada um dos nossos países. em particular Moçambique. Eu queria, entrando justamente na matéria, eu queria falar na cláusula 102, no que se refere, portanto, à questão da autoridade pública que deve registrar, né, todos os estabelecimentos públicos e outros bens pelos quais essa autoridade pública seja responsável. Portanto, isto está previsto no número 2, no 2, 102, cláusula 102, no número 2. Mas nos números seguintes, portanto, o 3 e o 4, já não faz referência à imperatividade das ações do ministro. Eu vou esclarecer porquê. Vou dizer porquê. Tanto no número 3, onde diz o ministro pode elaborar regulamentos. Depois, no número 4, o ministro pode adotar regulamentos. Penso que aqui, para mim, na minha opinião pessoal, devia haver uma certa imperatividade. Portanto, este pode devia ser substituído por deve. Deve elaborar regulamentos, porque é isto que permite que, de facto, o ministro seja obrigado a fazer esta atividade. Portanto, na minha opinião, era esta a proposta que eu queria colocar aqui, em vez de colocarmos como uma eventualidade, de se quer, se não quer, faz, eu acho que devíamos obrigar a que este ministro possa, de facto, elaborar estes regulamentos. Muito obrigado.
Thank you. Finally, South Africa.
Thank you, Program Director. May I speak my language, Misuse? Do you have an interpreter? You don't?
Which language is that one?
Isizulu.
I don't think we are capable
English is
of
not my
translating.
mother language. Okay.
Sorry, I think we're not
You
free
don't?
language.
Okay. Now I was just checking, moderator. My intervention is on section 81, clause 81 or part 8, which we extensively dealt with yesterday. But I just I want to welcome the suggestion of a debt management committee. And my colleague from Zambia spoke lengthy about borrowing, which is section 83. So I wanted to check with a good doctor there, who's a legal drafter, that while you have come with a good proposal of a debt committee, because that is very important, Parliament must have some sort of a broader forum instead of one person. Instead of one person take a decision to go and apply for a debt somewhere in the form of a minister. But when it comes to borrowing, I would like to see the same proposal, because in Parliament, we have different members of Parliament who are part and parcel of committees. For instance, in my country, in Finance Committee is different political parties. As my colleague of Zambia yesterday spoke about it, it's become also a very challenging when we just learn from the media or from the statement from the minister that I went to IMF to do some borrowing because of COVID-19. And as a result, I got 70 billion. And you don't even contribute as Parliament in a form of a committee to say what are the conditions. Because the famous conditions from the IMF, we know very well as Africa, as the region, is that social spending must be cut, and it affects the poorest of the poor. So therefore, I think we must insert a clause that will speak about the committee as well under the borrowing. I just want to concur with my colleague from Lesotho as well on the procurement regulation, Doctor. I agree. It's also, it poses a challenge in some of the countries because that's where corruption is taking place. So as we are saying that on clause 3, in that section of that talks about procurement, I think it's section 101. So you are also suggesting that a technology design must be considered. Have you also considered the view for the fact that that technology, which we can run from the fact that we have to be part of the global community as well, but the sovereignty of each country, especially if you are talking about the procurement. So I just want to get that view from the doctor on those few aspects. Thank you very much.
Thank you. Doctor, we have interventions from 7 honorable members. There's been
I did not hear the country jurisdiction of the last speaker. Could you advise me, please?
That is South Africa.
South Africa, I beg your pardon.
Thank you. So we have intervention from Lesotho, Zimbabwe, Eswatini, Angola, Zimbabwe again, Mozambique, and South Africa. Over to you, Doctor.
So in relation to the comments made by the honourable member from Lesotho, I very much agree with what she said, if I may say so, in relation to transparency under clause 101, subsection 2. And as she rightly says, the fact that we hark back to the public financial management principles, which are set out in clause 11, means that transparency and accountability are expressly articulated in relation to clause 101, subsection 2. Insofar as the honourable member from Lesotho also talked about the need to articulate the details in relation to the transparency aspects, I again respectfully concur. I think it is for consideration of SADC PF in due course whether model regulations might be of assistance, and that would be capable of dealing with her specific point about the publication of results. The reason why we can't talk about publication results here in a very high level primary legislation statute is it wouldn't really help us, because if we said you've got to publish results just as a one-liner in an act of Parliament, high level, the results could be published in a nugatory form. So in order to ensure effective regulation, the regulations under Part 9 might need to say what level of granularity the results are published at, where they're published, who can access them, how quickly they're published, and other details of that kind. So I think that is something for the Parliamentary Forum to consider in general, whether it should be giving some guidance as to the minimum content of procurement regulations, having regard to the publication of results and other similar matters. In relation to the comments made by the honourable member from Zimbabwe, in relation to clauses 98 and 99, I respectfully concur with what she says, and in particular, I agree with her that the linkage with the Auditor General is core to the efficacy of Part 9. In relation to the comments of the honourable member from Eswatini, if I may say so, he has correctly identified that the balance on the extensive powers of the executive under the bill in relation to matters of form and regulations of detail, he has correctly identified, if I may say so, that that balance of power resides in the criminal provisions that we will come to in Part 11. And when we come to that part, I will deal in particular with his question about the defense of the defense of not being able reasonably to avoid the commission of the offence, and I will expressly address his point about the mens rea for the different offences under the bill. But if he will forgive me, I will defer my addressing those remarks until we are dealing with Part 11. In relation to the points made by the honourable member for Angola, I respectfully concur with everything said. In relation to the comments made by the second honourable member from Zimbabwe, I respectfully concur that monitoring is indeed key and is addressed in the part. Her comments about gender neutrality, I think there may be a versioning issue here. I think the version in front of you may still contain one or two references to he. Those are a mistake. This is a gender neutral document. I can assure her that is the intention. And when you next see that there are one or two, I noticed at a late proofread, there are one or two that have crept in. They shouldn't be there and they will not be there in the final version. I assure her that this is a fully gender neutral document, as she rightly says it should be. In relation to the comments made by the honourable member from Mozambique in relation to clause 102, well, yes, I could turn subsections 3 and 4 into compulsory regulations. I mean, you know, again, compare the comments from Eswatini, you know, we've got too much, the executive coming in too much. And then as the honourable member from Mozambique says, but sometimes we think, well, maybe, hold on, we should require them to produce these regulations. It's a difficult balance. But if I can explain to him why it's a difficult balance, and I'm in the hands of the Assembly. We can jump whichever way the Assembly thinks is appropriate. But if I can just explain why we have the balance as we have between subsections 2, 3, and 4. So subsection 2 is a substantive requirement, and therefore it's a shall, because this is substance. I want a duty on public authorities to record assets, not merely a power. Now, subsections 3 and 4 are only dealing with matters of form, not matters of substance. And I don't want to say the government must interfere because, as the member from Eswatini said and other people said yesterday, we want to limit government interference in matters like procurement. We want to limit that so far as is reasonably possible. So there you have a power that where it is appropriate for them to regulate the form and not the substance, they can exercise that power, but always subject to parliamentary scrutiny for subordinate legislation under the model law. Finally, in relation to the comments made by the honourable member from South Africa, on the technical provision and the need, the technical procedures and the need to respect individual sovereignty, I respectfully concur with her remarks. And this is at the heart of contextualization that we discussed yesterday. The constitutional sovereignty of each implementing jurisdiction requires to be respected in the implementing regulations. She went back to part 8 to make a point on clause 81 and said, why can't we do the borrowing itself by committee? And I can only here refer her to what I said yesterday. Borrowing is an executive power of government. We cannot change that. Parliament is not an executive authority. It is not an executive body. We cannot put all powers in relation to borrowing in the hands of Parliament, but we have to have approval and control of Parliament so that Parliament oversees, controls and approves what the government does. And so far as possible, we have achieved that by linking it to the budgetary approval process, using the debt management statements, which will have the debt management committee input in the way that we discussed yesterday.
Thank you, Doctor. I'm sure, honorable members, it should be in your interest that we move on. Oh, there's one burning one. That's Namibia. Yeah, we can get it. Then I think from there, we move on. So, yes. Doctor will get one intervention. After you respond to that one, then you carry on. Over to Namibia.
Yes, thank you very much, Mr. Moderator. I'll be very fast. My name is Vipokwi Maharukwa from Namibia again. I introduce myself. I did promise to be fast, so I'll try and be quick and concise. The proposed section 96(2), the waiving or commuting of debt owed to government, it says it can only be done with the consent of the Ministry of Finance. I don't know whether we actually want to leave it that open-ended, or whether you actually want to put a specific body within the ministry or a specific person within the ministry to have that responsibility, because the moment it's left loose as such, it creates the opportunity for people to actually get into some untoward activities. I think section 101, I understand some members have raised it. To me, the whole proposed section is really a problem. Public procurement procedures should never be subject to the will of one person. An classic example again is Namibia, where it is actually contained in an act of parliament. We've actually just passed that now. In other jurisdictions where that might not necessarily be prudent, maybe it should be subject to a consultation of a specific body or commission of people. Lastly, the proposed section 103. This is for me a serious concern. You have individuals in government who engage or who is responsible to binding governments, legally responsible to other entities, individuals, and countries. There, I want to propose that we add an element of either lifestyle auditing of people who are charged with binding government, or a criminal, some sort of criminal element to that, or a reference to some sort of criminal code, when people are actually having some sort of conflicts of interest or possible conflicts of interest. I know the next section talks about that. But also lastly, that spot checks be done on government contracts, because you have individuals, you might have individuals who go into road contracts, construction contracts on behalf of government and all these things. And there's nothing that you can actually point to say that this person has actually benefited untowardly from concluding this agreement with this person, or has unduly negotiated an amount that is in excess of what is justifiable, simply because it's government knowing that this person is now going to get a benefit that no one is able to trace. So I think spot checks on these agreements randomly, and that element must come in, but also a lifestyle audit, compulsory lifestyle audits of people who actually conclude contracts on behalf of government should also be an element that we bring in to ensure that when people negotiate on behalf of government, they do not do so knowing that they get an undue benefit from agreements that that government concludes. Thank you. And lastly, maybe I just want to return to something that I said yesterday, relating to the principles. And I quite agree that things that we might not necessarily squeeze everything into the principles, but somewhere we should include that which I said yesterday, even if it's not in the principles, but maybe in the body of the text of the draft model law. I would tend to think that the doctor is aware of what I'm referring to. I don't want to go back to that.
Thank you, Namibia. Doctor, as I did mention earlier, once you respond to Namibia's intervention, we'll proceed with the other parts of the presentation. Over to you, Doctor.
In relation to the points made by the honourable member from Namibia, in relation to clause 96(2), he takes us back to part 8, and he suggests that the reference to the finance minister should be a reference to a specific person. The problem with this, again, is the contextualization of the implementation for each jurisdiction. And as he observed yesterday, we have difficulty enough identifying even committees that across all the jurisdictions of SADC. The honourable members for Angola and Mozambique pointed out yesterday they have a very different structure from some of the structures in many other states. I think it would be difficult to identify one office within the financial ministry, within the finance ministry, that would resonate correctly in all jurisdictions. However, his point is, of course, one that resonates in administrative law, and I agree with him that it would be required in accordance with clause 96.2 to have appropriate identification, not necessarily of a single person, it might be more than one person, but that would be a requirement in order for the finance ministry to show that it had complied with its administrative law duty under clause 96.2. On clause 101, I hear what he says. I note that he says that Namibia is setting out all its details at primary legislation. I suspect it will need to have some subordinate legislation cover for real world changes as things move on. And that again puts the initiative back with the executive, who are responsible for subordinate legislation. On clause 103, I respectfully concur with his comments about lifestyle audits and spot checks. Those would indeed form part of criminal investigatory techniques under Part 11 in accordance with the criminal procedure codes of individual jurisdictions. If he will permit me, I will just make the one observation that, of course, the problem about non-traceable assets is they're non-traceable whether it's done under a spot check or a specific investigation. But nevertheless, I accept completely his point that spot checking is an important part of criminal investigation, so far as permitted by a country's criminal code. And obviously, we don't here want to interfere with the balance drawn in relation to the criminal investigatory code of each country. His last point on principles, I fear I may not have recalled exactly what he said yesterday. I may have it in my notes, but I may not. Perhaps if you will permit me, moderator, I will mention that one of the difficulties about my appearing in front of the Assembly purely remotely is that there are a number of issues raised where I think it might have been helpful to have discussions in the margins with individual contributors to discuss exactly what they would like to see, and to see whether anything can be done without unreasonable structural disruption at this stage. I can't do that on screen, but perhaps in relation to his point on principles in particular, if he would communicate with me through the Secretariat, I would certainly like to listen carefully to what he said.
Thank you. Has he managed to respond to your Namibia? Are you okay? The last part, because he says he can't remember exactly what you said, but he has attempted to tap, I think, the issue of the principle that we raised. So are you okay?
Yes, it's fine.
Okay.
It was the part on sustainability and responsibility.
Okay.
But I think I'll communicate with the Secretariat as he suggested, and then maybe we can take it from there.
Thank you. Before we proceed, perhaps SG may wish you have something else to say?
No, thank you very much. Good morning, honorable members. Good morning, Dr. Greenberg. Just a procedural issue. I'm wondering how you're doing on getting consensus on the conflicting issues that are being tabled. Can you hear me? Okay, sorry. Probably it's my mask. I was just checking in to see how we're doing with really consolidating consensus on some of the issues that you're agreeable with and the propositions that are coming from the floor. Is there anything that we need to do?
No, I'm assuming, Madam Secretary General, I'm assuming that where I have in my responses, in a number of places, I have said that I propose to make the change sought, unless I hear serious objections. There have been no serious objections. So delegates who have heard me say that I propose to make the change that they suggest should assume that they will see that in the next draft.
Okay, thank you. I needed to, and the balancing act, I was wondering where we want to make things mandatory in some instances and where we want to, would
So
it be
I
to your
have-
discretion?
Yeah, so I have specifically, in relation to 2 or 3 instances yesterday, I specifically accepted the suggestions to make them mandatory. Where I have not specifically undertaken to do that, members should assume that that has not been agreed, and they should therefore assume that the balance will remain as it is, unless they speak to you and you tell me otherwise.
Thank you. Is that in order, honorable members? Thank you, thank you. I just needed to make sure. So, sorry, we will see it in the next draft, which means we'll circulate it before the assembly. And we'll continue to do so in Malawi on the floor on adoption. Unless we get comments earlier, because it will affect translation. So if we get comments too late, it means we can't circulate the draft document. And then it will affect other languages.
Yeah.
So if that is why right now we're holding a draft that is still, changes have been made, but because of language and translation issues. So unless we set a timeline from here towards Malawi, and if we get those comments before, we'll be able to circulate the changed documents. Otherwise, it will have to be done on the floor.
But
Before publication.
Yeah, but it's very difficult, isn't it? Because if we make a change at the request of one delegate and we then produce that shortly before validation, we may suddenly find there are other delegates who want to go back the other way. So that's why I think that where I have indicated that I am proposing to make the change sought, I've done so in the course of our deliberations so that people have been able to object if they didn't like it. And so far as I can see so far, no one has objected. So that's why we've identified changes sought by everybody that effectively have the general approval of the Assembly here today.
Thanks so much, Madam SG. Or Lesotho, you have something else on the same?
Yes, thank you. I just wanted to align myself with this discussion. I would like to suggest that since Dr. Greenberg is making reference to some areas that we are yet to go to as we're presenting, as he's presenting, we might want to give the date, the timeline to the end of the presentations, because some of the areas that he might have given responses, as we flow with the document, we are still trying to align the feedback that he's given. So if by the end of the presentation we're still okay with what he referred to in the subsequent sections, then we will take it that we are in agreement. I think it would be a concern that we take some issues from this forum, and we are yet to make submissions being considerate of the timelines for the translations, etc. That is my submission to the honorable members. Thank you.
What do you make out of that proposal, suggestion? I think it's agreed generally. Doctor, you have taken note of the suggestion from us?
No, that's not a matter for me. That's a secretariat.
Thank you.
I can't deal with that.
Thank you so much. Thank you so much. Thank you so much, Doctor.
No, indeed.
Secretary General. Order, honorable members. Madam SG.
It's in order. Thank you.
Thank you, Secretary General. Let's proceed, Doctor, with the presentation.
Yeah. People have to understand that I'm a mere drafter. I just do what I'm told by the Secretary General and others. issues of timetable are way above my responsibility.
You are
Part
you are
10.
protected, Honorable Griffith. You are
Yeah. Right, part 10, public accounts. Again, the public financial management principles are supplemented by specific accounting principles in clause 106, which incorporates the public financial management principles and generally accepted accounting principles. I remind honourable members that, and other distinguished delegates, that that is a generally accepted legislative term, and it sounds in administrative law. It means that accountants are expected, and this applies to public accountants as to others, they are expected to keep up to date with the accounting practice of their profession, and the courts are well used to applying standards of international, regional, and local best practice to accounting principles. There is a duty to maintain guidance on the general accepted accounting principles, and that will be in accordance with what the honourable member for Mozambique said in relation to part 9. That is a duty because it requires to supplement the principles of the principles of the model law. However, again, it will be subject to parliamentary control. Clause 107 deals with a duty to prepare resource accounts, and we discussed resource accounting as a principle yesterday, and this is a fundamental issue in relation to modern accounting practices, that cash accounting does not give a full and fair picture of what is being done within a ministry, and therefore the resource accounts are required in accordance with 107.3 to present a true and fair view and to conform to generally accepted accounting practice, subject to public service adaptations as required. The Auditor General controls the resource accounts in the ordinary way, and the accounting officer is responsible. The honourable member for Namibia, I think, is talking partly about responsibility in relation to principles in the bill, and we have specific flashpoints in the model law where individual responsibility is required, and section 107, clause 107.7 is a specific example of that. Clause 108 gives the Auditor General the duty of examining resource accounts, and those feed into the whole of government accounts that the Finance Ministry is required to prepare under clause 109. Clearly, the preparation and provision of information is crucial to the preparation of proper and accurate accounts. Section 110, clause 110, therefore gives a specific set of provisions in relation to duties in relation to the provision of information that is internal, and it is balanced by the provision in clause 111, which gives the Auditor General, with independence from the executive, the duty again to examine accounts and send them to certify them either as representing a true and fair view or not presenting a true and fair view. There is always a possibility that one will need supplemental departmental accounts, and that is dealt with by clause 112. As to the process and procedure, clauses 113 forward deal with the process. The Finance Secretary is responsible, again, picking up the point from the honourable member from Namibia, is personally responsible for the maintenance of government accounts. Financial statements are required in accordance with clause 114. Again, supplementary regulations, in this case, matching the point made by the honourable member from Mozambique, are required, although they are procedural, they're required. And finally, at the request of a consultee earlier in the process, specific provision is made about the possibility of accounting for donor fund treatment separately under section 116. That may be a donor requirement, or it may be an internal audit requirement. And finally, clause 117 sets the financial year in accordance with the practice of each jurisdiction.
Thanks, Doctor. Any comments so far, honorable members? I can see Angola, Zimbabwe. These are the only two hands so far. I have Angola. Over to you, Angola.
Muito obrigada, senhor moderador. Eu, sobre este capítulo, tenho, de facto, algumas questões. A primeira questão tem a ver com o prazo que deve ser que medeia entre o fim do exercício e a apresentação da conta no Parlamento, até a apreciação. Portanto, normalmente, segundo a nossa legislação, nós, quando apreciamos a conta, já se passaram 2 anos, e o efeito das recomendações que nós podemos fazer a nível do Parlamento nem sempre são ainda atuais. Essa é a primeira questão, e eu gostaria, de facto, aqui de vermos qual seria o melhor prazo para que nós pudéssemos, a nível dos nossos parlamentos, apreciar a conta geral do Estado. A outra questão tem a ver com aqueles ministérios que nem sempre apresentam a execução, os relatórios das suas contas, portanto, os relatórios da execução do orçamento. Isso também cria alguns problemas ao próprio Ministério das Finanças, porque depois o Tribunal de Contas, quando tem que dar o parecer, o Ministério das Finanças acaba sendo penalizado pelo facto de alguns ministérios não apresentarem as contas atempadamente. Isso faz com que, algumas vezes, o Ministério das Finanças apresente a conta geral ao Parlamento com algum atraso, porque fica a aguardar que alguns ministérios apresentem, e também aqui eu gostaria, de facto, que víssemos um prazo para que os ministérios, eu vi aqui 3 meses, mas não sei se de facto nesses 3 meses tem a ver com as contas dos ministérios ou se é um outro prazo. Essas são, por enquanto, algumas questões que eu tenho. Tem mais a ver com prazo e também o processo de reintegração de responsabilidade financeira aos gestores que, de facto, não cumprem com as normas e os regulamentos para a prestação de contas. Portanto, gostaria também de ver aqui bem espelhado nesta proposta da lei modelo sobre finanças públicas. Muito obrigado.
Thanks so much, Angola. Then we have Zimbabwe next.
Thank you very much, moderator. My observation is on section 116 on donor funding. I feel this can be a source of various contentions. Can we not have an expanded version of how the ministry and departments and government units are supposed to interact with the use of donor funding? In many countries, the funds become a source of conflict in the absence of a properly structured interactive framework. My feeling is that this provision is too scant and too skeletal. Thank you.
Thank you. We have now two more hands, Lesotho, then Tanzania, and South Africa. Three more. Lesotho.
Sorry about that. I had misplaced my notes. Well, once again, my name is Honorable Tapa Musena from Lesotho. Thank you very much, Dr. Greenberg. I seek clarity on 107, 107.1 against 107.7. 107.1, the interpretation could be that it refers to the resources acquired of 107A and B of it, referring to the finance ministry. The interpretation one could have is the relation is directly linked with the finance ministry only. And sort of say relating to the finance ministry against other ministries. That is something that is not clear, because when you look at 107.7, sorry, it clearly talks to various ministries. It says the accounting officer of the ministry shall be responsible for the preparation of the ministry's resource accounts. And that for me also includes the Ministry of Finance. Whereas 107.1, it's sort of like it's referring to the use of the resources of the finance ministry within other ministries. I think that's the clarity that one is seeking between these two. That's the first one. The second one is on 108.2B. It says if the finance ministry sanctions the relevant use of resources, the Auditor General shall treat it as always having had the finance ministry's authority. The concern is, isn't that opening up space for undue power? As we have discussed yesterday, that it's the finance ministry that is given the mandate or the powers. And now when we say if the finance ministry sanctions the relevant use of resource, that is the ministries that would have used or taken the undue power, and then the finance ministry only gets informed afterwards, then it's taken to have been the finance ministry's authority once the process has taken place. Aren't we opening up space for undue use of power? Let me just put it, leave it at that. And yes, indeed, I concur with my colleague from Zimbabwe regarding the donor funds. The speculation is this 116, it's just too brief, and it's not really detailing what the donor funds are expected how the donor funds are expected to be treated. Yes, one could look at 120 on the misuse of public funds, but that would only be after a particular defined structure of the use of public funds has been made, which is sort of silent right now. So even if we can identify the misuse of public funds, but would they be inherent within that part that talks to the donor funds? Those are the questions I submit. Thank you.
Thank you. Next is Tanzania.
Thank you very much. My name is Zedi, a member of parliament from Tanzania. I want to comment on part 10 that deal with the public accounts principle and preparation of accounts. We understand that we have international public sector accounting standard, IPSAS. Then I thought that this is standard IPSAS would have been mentioned somewhere as a benchmark for all the accounts that will be prepared regarding the public funds. So I haven't seen it mentioned anywhere.
So I just want to know that, don't you see that it's a proper IPSAS being used as a benchmark in all accounts that will be prepared regarding public funds? But it's not mentioned anywhere. And we have this standard IPSAS.
Thank you. And finally, South Africa. I had a hand from South Africa, unless.
Yeah, no, thank you very much.
Thank you.
Doc part 10 on public accounts. I think this is whereby the public as well are very interested to know about their public money as taxpayers' money. It's well and good that in section 106, you speak about principle, but the fact of the matter, you know very much that politicians does not subscribe to any principle nowadays. So therefore, can't we just suggest some mechanisms to ensure that there's a public accountability on public accounts by government? And as well as I want to check with you, section 121 that talks about maladministration. Well, I know that in most of the countries, we rely on Auditor General reports and Public Accounts Committee also to help us in terms of the accountability, in terms of the public accounts. But can't we just suggest something as well? Because Auditor General, they does not have powers. They do and give us reports as members of parliament. And most of the things are exposed in terms of what went wrong in terms of the public accounts. But they just refer cases because of the lack of powers. They just refer to police, to other people to take those cases that were exposed in terms of corruption. So here at this level, can't we suggest some of the things that will be sort of strengthening the mechanism to this effect? Thank you very much.
Zambia. After Zambia, we'll give it to our legal drafter to respond.
Okay. Thank you so very much. My name is Princess Kasune from Zambia. So on clause 108, it is talking about scrutiny. And I think I want to echo a little bit of what the last speaker was just speaking to. That is the lack of maybe teeth to bite somehow. And if there are ways we can add a little bit of muscle to once the reports are done. But my point though is in terms of scrutiny, I do not see anywhere where we are trying to suggest, I know it's going to vary from one country to another, the time frame. Here on is this 4? It says, 108, and then on subsection 4, the minister shall lay accounts and reports received under subsection 3 be before Parliament as soon as reasonable, practicable. So my question is, don't we have a way of putting a little bit of some time frame? I say so because in Zambia, for example, I think if I'm not mistaken, the report almost come, is it after 2 or 3 years? Did someone say yes? Okay, thank you. And that could be the same scenario in other countries. What you find is that the controlling officer has either left the persons, they already know that they're being cited, they have changed offices, and this just makes it an academic exercise. And I wonder whether there is a way, us in here, using this model law, we could try and strengthen that weakness that is existing. And I hear a lot of yeses. I want to take it that different countries may be facing similar situation. Thank you.
Thank you. As I did mention, we have interventions from 6 honorable members: Angola, Zimbabwe, Lesotho, Tanzania, South Africa, and Zambia. Over to you, Doctor.
In relation to the point made by the honourable member from Angola, which was repeated by the honourable member from Zambia in relation to time frame, yes, there is no reason why more specific timeframes could not be introduced at contextualization, and clearly timetable is of the essence for the reason that the honourable member for Zambia gave. I would just, and there's no reason why that shouldn't be done and that shouldn't be encouraged at the implementation stage of the model law. But I would just like to make one point to the honourable member for Zambia and the honourable member for Angola in relation to 1084. It's a point that I made yesterday. As soon as is reasonably practicable is not mere persiflage. It is a concept of administrative law that the courts will enforce. Now, in the case that the honourable member for Zambia expounded in relation to a delay of several years of presenting a report, that clearly is a breach of the administrative law requirement to produce the documents as soon as is reasonably practicable. And in a situation where the courts are well focused on maintaining administrative law, an action could be brought to implement 1084 accordingly. In a situation where the courts are not focused, then giving a timetable in the model law wouldn't work anyway. So the issue here is the model law can set out a structure for how things ought to work. If you have a situation where the executive has untrammeled power and the courts are incapable of controlling it, the model law cannot prevent that in the same way as it cannot prevent any other diminutions of effective rule of law. The honourable member for from Zimbabwe and the honourable member from Lesotho both questioned the brevity of clause 116. And I of course hear what they say. The reason for it is this: we didn't have clause 116 in originally. We were asked to interpolate it by a specific consultee who said that the arrangements for donor funds, the contract, if you like, the treaty or the contract for donor funds may require specific accountancy practices. And therefore, the reason for not being, and we thought that was a good point, so we've put the clause in. But the reason for not being more specific is that the arrangements will depend on the contract or the treaty. So again, I would say to the members from Zimbabwe and Lesotho that, yes, again, we could be giving guidance in relation to the contracting of treaties for donor funds as to what the accounting requirements should be, and that would be the place to tighten up those issues. The honourable member from Lesotho raised a point on clause 107 and contrasted subsections 1 and 7. Her point is clearly right, if I may say so, and I will make that change, again, unless I hear any objections from the Assembly. But failing that, she should assume that that change will be made. In relation to her point on clause 108 2b, yeah, look, of course, of course, abuse is possible, but I think perhaps, if I may say so, she needs to remember that the Finance Ministry always has the power to sanction the use of resources. The point 108 2b is not a special additional power. It's purely about retrospective sanctioning, and you can't stop that. The point about the checks and balances under the bill is we can say, hold on, you've used resources that haven't been sanctioned, yeah, and therefore you've used those resources improperly, which could potentially trigger criminal liability if it's a criminal case, and it certainly triggers Auditor General involvement. because that's the opening words of 108.2. But if the Finance Ministry then says, well, our way of regularizing that position is to give retrospective sanction, you can't prevent that. And is that capable of being open to abuse? Yes, it is. But then sanctioning of expenditure in advance is capable of being open to abuse. I've responded to the honourable members from Lesotho's point on 116 in my response to the honourable member from Zimbabwe. The honourable member from Tanzania mentioned Ipsos. Yes, of course, I agree. Ipsos is one of the core accountancy benchmarking tools. It's not the only one, of course, and of course it may change. So we're not referring to it specifically on the face of the model law, but he is, of course, correct, if I may say so, that it is presently a standard benchmark, and we could mention it in the explanatory material. In response to the honourable member from South Africa's desire to see more accountability mechanisms in relation to 106, that feeds back to the Public Accounts Committee mechanisms earlier in the model law. Her reference to the powers of Auditors General, well, the model law does give Auditors General enhanced powers compared to their present position in some jurisdictions. Jurisdictions vary, but she is correct, if I may say so, to point out that those powers are investigatory. The Auditor General is not a prosecuting authority, but of course, where the Auditor General, as she says, where the Auditor General uncovers criminality, the provisions of the prosecutorial code will be triggered. In relation to the comments made by the honourable member for Zambia on clause 108, my response is the same as to the honourable member for South Africa that I've just made. And in response to the honourable member for Zambia's comments about timeframes and section 108.4, I dealt with those comments when I spoke to the comments from the honourable member from Angola. And again, contextualization is key here. If we were to attempt a single set of fixed timeframes, we would not be likely to find one that suited all jurisdictions or indeed all circumstances.
Thank you. Is it in your interest, honorable members, that we move on? Or there's one from Namibia. Okay, Namibia, then Lesotho again, then from there, I think we should move on. Namibia?
Yes, thank you very much, Doctor.
The Angola, thereafter?
Donor funds proposed section 116. You have circumstances where sometimes donors would give funds to go towards a specific purpose, and that money never reaches that purpose, or it is not accepted by central government. Somewhere, somehow, I would propose that we include in that section an onus on central government or the minister or whatever body is charged with receiving or accepting such funds to alert the local communities, be that a local government, local authority or regional authority, or in some jurisdiction, the traditional communities, so that people on the ground are aware that X donor has intended to give us this. Where is that money? Or an explanation of as to why the country did not accept that money. I move on to section 122, recovery. I think given the latest drive of what I believe is a region-wide approach on corruption, I would tend to think we should include in that provision bodies more than the Ministry of Finance. Something to the effect of, should the Ministry of Finance fail to recover proceeds of say, for instance, corruption, that member states move towards giving for instance, the ombudsman or public defender, whatever any jurisdiction calls it, the teeth and the power to move for the recovery of proceeds of these public crimes. Or perhaps create a situation where the ministry has a direct onus to communicate with 2 or 3 other bodies charged with the same responsibilities, that in the event that central government fails to do that, you have 2 or 3 other bodies responsible and able legally to act for the public and make such recoveries. I see the draft also then addresses in 120 what I was saying earlier about wasteful expenditures and all those things. So I would also then go ahead and propose that we do then include the possibility of doing spot checks on government contracts, the possibility of adding to that what is this? Adding to that the lifestyle audits of people who are charged with signing contracts on behalf of government. That should it be that some jurisdictions don't have that we drive towards that, because it is common cause and it is a pain in the neck of public administration, that people who are charged with negotiating deals on behalf of government amass resources that they can't explain. And somewhere it must be nipped in the bud. And I think it is the duty of this, if I can call it, Legislative Assembly of the SADC arm, to actually drive our region towards ensuring that spot checks are done on these contracts and that these officials are actually taken to task on how they amassed resources without actually being able to explain it. Thank you very much. So I think we should put in that provision concretely there.
Thank you, Lesotho.
Thank you very much. I also wish to go back to 116, the donor funds. Dr. Greenberg had submitted that we may wish to propose how to expand on this. And I have a few recommendations, or one recommendation with a few elements that the donor funds, when they are received, information should be clearly specified, which is not necessarily limited to the following: the source of the donor funds, the intended purpose, the conditions of funding, and the attached benefits, if any, to the funding. That is the submission on that area. Still on donor funds, I seek the guidance of Dr. Greenberg on funding that is sometimes sourced for states, which is not necessarily going directly to the coffers to the public coffers. I didn't know where to ask this question, but I felt maybe this is the right space to ask, because we are not necessarily talking about public funds, but we are talking about funds intended for public use, where it would be maybe NGOs or NGOs or different entities who would be seeking support or assistance, maybe from the international community, but you find that there's a condition that the Ministry of Finance approves that such funds may be solicited for the country. So those funds are not necessarily getting into the public coffers, but they're intended for public use. And sometimes the executive might decide not to allow these funds, even if they don't necessarily have any, they're not requested to make any payments linked with those donor funds. So I seek the opinion of Dr. Greenberg. How should Parliament deal with this? Should it be our business? Should we just turn a blind eye? Do we have any contribution whatsoever in such transactions? For example, with COVID-19, you would find that there are so many donors that are providing assistance to different member states, and those funds are not necessarily getting into the public coffers, but the authorization for such funds to get into the countries would be through the Ministry of Finance. That is, I just seek clarity on that. Thank you so much.
Finally, Angola.
Obrigada mais uma vez, senhor moderador. Eu peço desculpas por voltar à questão dos prazos. O que eu sei que seria difícil para a nossa comunidade, tendo em conta a especificidade de cada país, definirmos aqui um prazo que fosse aceito por todos, ou que fosse possível ser aplicado por todos. Mas eu considero que, a nível da lei modelo, deve haver um prazo. Aliás, no número 117, diz claramente: o ano tem início em data, e nas notas de rodapé, a data a ser inserida de forma a refletir o exercício financeiro de cada jurisdição e a calendarização dos ciclos orçamentais e contabilísticos do Parlamento e do exercício. Portanto, me parece que esta data deve ser uma data que não extrapole muito o prazo do exercício, que não seja uma data muito distante do prazo do exercício, porque, como eu disse inicialmente, elaborar, apreciar uma conta 2 anos depois do orçamento ser executado, não sei se traz algum benefício para as nossas realidades, para os nossos países. Por outro lado, eu também estou a pensar no futuro. Se nós pretendemos um parlamento regional, me parece que, de facto, devemos aproximar posições, devemos aproximar métodos, devemos aproximar alguns prazos em relação às datas que nós devemos apreciar as nossas contas. É um bocado nesse sentido que eu gostaria de voltar a rebater essa questão, porque é de facto muito preocupante o que nós assistimos, e me parece que isso não é um problema só da Angola. Eu sei que, a nível das outras leis modernas, pelo menos servem de freio para determinadas ações, e no que toca a essa lei das finanças públicas, me parece que, de facto, nós estamos com muita expectativa em relação a ela, e talvez fosse bom algumas questões que são preocupações para nós serem abordadas claramente aqui nesta lei. Uma delas é essa questão dos prazos para os parceiros das contas dos exercícios. Muito obrigada.
Thank you. Doctor, you get 3 interventions: Namibia, Lesotho, and Angola. And thereafter, then we'll have at least a 15 minutes break. Over to you, Doctor.
In relation to the point made by the honourable member from Namibia, the first point related to hypothecation of funds, and in relation to clause 116. And yes, of course, donor funds should be properly hypothecated, and the contract for the donor contract should set out the element of hypothecation and the mechanism by which it will be assured. As a result of that, my response is the same, that yes, of course, under clause 116, the hypothecation element of the contract should carry through to its implementation. And again, there will be potential criminal implications of failure to comply with the hypothecation requirements. The honourable member for Namibia talked about publication requirements. Of course, that's not for the accounting. That's not for the accounting part, but it is something for the Public Accounts Committee. It is within the purview of the Public Accounts Committee in accordance with their requirements for transparency, and in an appropriate way for each jurisdiction and each context, they will be expected to impose transparency requirements. The honourable member for Namibia made 2 points relating to clauses 120 and 122. Those clauses are found in part 11, to which I have not yet spoken, and if the honourable member will permit me, I will return to those when I deal with part 11. The honourable member for Lesotho again talked about donor funds, and she was talking less about hypothecation and more about the use of special funding mechanisms and account preservation mechanisms. And I agree with what she said. And of course, what we spoke about yesterday in relation to special funds, one of the uses of special funds is for protecting donor funds. That's one of the permitted uses. In relation to the comments made by the honourable member for Angola about synchronizing, standardizing timescales across the region, that is very much not a matter for me. That's a question of policy. A number of members spoke yesterday about the importance of recognizing the sovereignty of each state within the SADC region, and it may be that some states would regard a standardized time frame as an interference with their sovereign rights to determine their own timescales in an appropriate way, but that is very much a matter of policy and not a matter for me. I have heard what the honourable member for Angola and others have said about timeframes, and it seems to me that one thing that might be helpful, and again this is something that ideally we would then discuss, and we can't really do it in this forum, but something that might be possible might be helpful would be to add some appropriate specificity to the preamble as a way of indicating the idealized time pressures and the unacceptability of the kind of multi-year delay that honourable members have mentioned. And that's something that I will discuss, will consider and discuss with the Secretariat between now and the presentation of the final version for adoption.
Thank you, Doctor. Honourable members, we'll take a short break. The program says it's 15 minutes break, and now my time is 10:48. So perhaps we resume our proceedings at 11:08 or 11:10, 10 past 11. Thank you so much. So we break for our healthy break and then our tea break, or we come back at 10 past 11. Welcome back, honorable members. Welcome back. My time is 20 past, so we have overflown our time by 10 minutes on the agreed time, but most welcome. Dr. Greenberg, are you there?
Yeah.
Thank you so much. Let's proceed from where we stopped. Doctor.
So we are going to deal now with part 11, financial misconduct, misuse and maladministration. The provisions of part 11 are designed to create an effective line of criminal and parliamentary enforcements for the implementation and effective enforcement of the provisions of the model law. The part addresses actions by public officials defined widely in clause 118. Clause 119 creates an offence of public financial misconduct. It is a strict liability offence of failure to comply with provisions of the Act or regulations made under the Act. And it is a general offence. There is a defence, and a question was raised about that. I'll return to that in a moment. Clause 120 is another criminal offence of misuse of public funds. These are broad criminal offences. They may overlap with pre-existing offences in particular jurisdictions, in which case they will be contextualised, but they are the basic minimum components required to ensure that there is responsibility, to go back to the idea raised on a number of occasions by the honourable member from Namibia, I believe, in relation to personal responsibility, and it is important for effective implementation that officials know that they could be personally criminally liable for failures to comply with the Act. There are occasions when it is very difficult to prove criminal liability, and that point was being made earlier today in relation to procurement issues as well, by the honourable member from Lesotho, and as a result, clause 121 creates a concept of maladministration which is not a criminal offence, but it is identification in a public report of failures to comply with the Act or for improper behaviour of another kind. These are reports of the Auditor General, the Public Accounts Committee, or investigations or inquiries established for that purpose. The Auditor General and the Public Accounts Committee are independent of the executive, so these are independent reports. And they do not become criminalized, obviously, they are not criminal offences, but they could link in to disqualification where Parliament has power to make an appointment or withhold an appointment. Parliament might decide one of the reasons for not appointing somebody is that they have been found to have committed maladministration in a public report under section 121. In order to preserve the separation of powers, this is not a criminal offence because maladministration reports are not produced by the police or by the courts. They are produced by independent public officers, and for the purpose of preserving the separation of powers, they are therefore not criminal offences. Clause 122 deals with recovery. Clause 123 I've just mentioned, and clause 124 is designed to require the government, the executive, to think about other ways where necessary of enforcing the regulations. Now, a specific point was raised earlier on by the honourable member from Eswatini about the form of clause 1192. And I will deal with that point now, if I may, and then I will go on and deal with the points raised by the honourable member for Namibia. In relation to the point raised by the honourable member from Eswatini in relation to 1192 and the broad defence, and a similar defence is found in section 120, subsection 3. Now, when you create criminal offences, you have a choice. You can either make them subject to a mens rea requirement, willfully, knowingly, recklessly, or something of that kind, or you can make them what we call strict liability offences. If you have done the act, you are criminally liable without having had any particular mens rea, any particular intent, state of mind. Now, the problem is this. If we said you're only criminally liable for breaching the regulations or breaching this act, where you did it knowingly or recklessly or something of that kind, it's very, very difficult to prove. The mental element is very difficult to prove. And as a result, what tends to happen is you don't get any successful prosecutions under the act at all. Yeah? So on the other hand, so therefore, the primary offence is a strict liability offence. If you did fail to comply with the act, then you've committed an offence. And the prosecution do not need to prove that you intended to commit the offence. However, that then gives you another problem, because you could have a junior official in a department who has committed a technical breach of the model law of the act, and she or he could not have done anything to avoid it. They failed to provide the accounts. Why? Because they weren't given the accounts internally, for example, or whatever it is. Now, we can't have a junior official being made criminally liable where they did everything possible to avoid failing to comply with the act, and criminal liability in that case would be inappropriate. So the point about 1192 is what it says is this: the prosecution don't have to prove intent. They just have to prove failure to comply. But once they have proved that, it is open to the defense to show, and it's their burden, to show that they couldn't possibly have, they did everything they could to comply, and it wasn't anything that could reasonably have been expected of them. And that gives you the balance. The prosecution don't have to prove state of mind, but the defense can prove non-culpability. Now, if you look at clause 120, you will see that there are two branches of misuse of public funds. There is contravention of provisions of the Act under paragraph A, and then there is fruitless or wasteful expenditure of public funds under paragraph B. Paragraph B, there is an intent requirement. It's knowingly or recklessly, because it's not a technical breach. It is positive action, wasteful expenditure of public funds, which is a relatively subjective concept. And therefore, the prosecution there does have to prove that you were knowing or reckless. And as a result, the defense in subsection 3 does not apply to limb B, to paragraph B of subsection 2. It doesn't need to, because the prosecution there have already proved a mental state. 120 2A is another technical breach like clause 1191, and therefore you do have to have the non-culpability defense in subsection 3. I hope that deals with the comments of the member for Eswatini, the honourable member for Eswatini, the honourable member for Namibia asked whether more bodies could be included in clause 122. Well, that will be a matter for the criminal law of each jurisdiction and not for this law. He also spoke about spot checks, lifestyle audits, and unaccounted wealth orders. Yeah, again, all those things are possible, as I said before, but they are a matter for the criminal law of each jurisdiction, not for this law. How you investigate crime is not a matter for the Public Financial Management Act. It needs to be dealt with as an overall overarching, in accordance with the overarching criminal law of each country. However, if it would help the honourable member for Namibia, we could mention spot checking, lifestyle audits, and unaccounted wealth orders as an enforcement issue, again in the preamble, linking in to the enforcement and implementation mechanisms of each jurisdiction. And unless I hear any objection from any member of the Assembly, I will make that change to meet the proposal of the honourable member from Namibia.
Thanks, Honorable. Thanks, Doctor. Interventions are welcome, honorable members. I think on part 11 of the presentation, I can see Eswatini, then DRC, Lesotho, Zimbabwe, and then in Namibia. In that order, 1, 2, 3, 4, 5. Yeah, let's start with Eswatini. Over to you, sir.
Thank you very much, Mr. Moderator. I am much indebted to the explanation given by our esteemed drafter with regards to this question of the strict liability provision making it an offense, criminal offense as it were, well, to be in violation of certain sanctioned actions or non-actions. As I say, I'm happy the way he has explained it. But I may just seek his opinion, advice, albeit that he has explained it, but it could be further explained. 1192. 119 subsection 2. Going back to it again, notwithstanding the explanation, which I'm very much grateful about. What is the import of this provision there? It is a defense. Who is being alerted here? Like I was saying, well, it looks like everything is on the executive through the minister, maybe of finance and his auxiliary services. So when is this defense being brought? In a court of law or within a tribunal structure within the Act which I haven't come across yet. And that's why I was wondering if it could not be modified instead of it is, it looks a little casual and weak to me. Yet it is intended to defend cases of vicarious responsibility. That's what I think it's all about. Your subordinates might in good faith do certain things, but because you are the controlling officer, you can't escape 119, maybe on a case of vicarious responsibility. I do appreciate this section, but couldn't it be modified, maybe worded such that it may be or it shall be, rather than just making it a sentence in passing? This is the way I look at it, Mr. Moderator. But by and large, I'm happy, but I'm not too sure if what appears to be offensive within this model law is the beginning and end of the executive, and how is it transferred to the normal conventional structures of dealing with criminality? I thank you.
Thank you. Next is DRC.
Yeah, I'm Honorable Tumba from DRC. My question is related to the comment the doctor have made. And having listened his comment, this allow me actually to ask a question. There've been a lot of multiple breaches of law in finance ministers. We have a lot of information about that. In the same time, we also have a lot of proof, evidence. But sometimes we come to the wall because the minister might be have a support with somebody. After his comments, after the comment made by the doctor, the presenter, I need to ask a question in how much the parliament can do to stop misuse of finance public, especially in money area. We talk about finance minister, budget minister, so on and so forth. I submit.
Thanks, DRC. Next is Lesotho.
Thank you very much for the opportunity and I must confess, some interesting jargon when you're not a legal person and you've been listening to Dr. Greenberg expand on this section with such humongous words. But I wish to put forth a scenario which I'm wondering if this section is helping us deal with. One of the reasons that was stated while we're drafting the model law on public financial management has to do with the resolutions or the recommendations of the reporting of the Public Accounts Committee, where they end up just being reports and nothing happens beyond that stage. And the draft clearly shows that we can use Parliament to present resolutions regarding the findings of the Public Accounts Committee, for example. Now, case in point, we have the resolutions of the Public Accounts Committee, yes. We have, sorry, the report and the resolution of Parliament, yes. It has even stated, I'm talking a situation from my country, it stated the findings, the timeframes where recovery is expected to be made, or a response reaction is expected, and you find that nothing happens. So I'm just wondering how the model law directs us to act beyond that stage, when the resolution of Parliament just turns into an obsolete instruction. Where in this model law are we guided on how to act beyond that stage? We have on 124, it talks to enforcement regulations, which may include creating criminal offenses. And now one wonders who exactly does what beyond the resolution of Parliament, which states clearly the misuse of public funds, and where in some instances a person has publicly acknowledged that they have bypassed the regulations or the law, and this information is in the eyes of when you're looking people that can actually act on behalf of the state, and they don't necessarily do so. I'm referring to, for example, in Lesotho, we use the DCEO, the Directorate of Corruption and Economic Offenses, and one would expect, maybe ignorantly, that they would react to outcomes of parliaments, such as the resolutions that are made. They would actually even react before the reports are drafted by the relevant committees, such as the Public Accounts Committee, when somebody publicly declares that they have knowingly misused public funds. You have the police, on the other hand. They're also clearly aware of the misconduct, of the legal infringements, but nothing is necessarily being done. So maybe ignorantly, I am expecting that they would react and take the necessary steps to put the matter where it really must be in handling the public funds. So how is this model law helping us beyond that stage? Where exactly do we look, where it guides us, where somebody is held accountable and something is actually done to get the necessary responses regarding the misuse of public funds? I stand to be guided. Thank you.
Thank you, Lesotho. Zimbabwe, next.
Yes, thank you. Let me join the rest in thanking the doctor for this particular section, but perhaps really just to strengthen and propose several other issues that we may need to deal with. When you look at 122 on the recovery, and we are burdening the treasury on its own in terms of actually having to operate a scheme, when you may have already other existing government institutions who are dealing with issues or cases. And I note in the whole document that there's no way we mention about corruption. Because when you move from bribery, proceeds of crime, you know, it's about assets, about drugs, about everything else. That is grand corruption, because it takes place at the initial stage of procurement. And the other matters are appearing to the minister to be relevant. Which are these issues? And my proposal is that there is need then for Parliament to take over at this stage, because the committee is responsible will have actually have had information from the AG, for example, the Public Accounts Committee, on the seizure, the search, and the apparatus. But I hope and trust that at the very beginning, those public officials have got where they have to declare their wealth before they are in the offices, so that you can actually make the checks and balances in terms of where did you get what you have now. That's number one legislation. In Zimbabwe, for example, institutions that come to play into my mind is the National Prosecuting Authority, because already when one is involved in the bribery and the proceeds, which are big assets, some may not even be in the country. You need then also to engage the reserve banks of the nations, financial intelligence units, also to carry out investigations. In Zimbabwe, we also have the Zimbabwe Anti-Corruption Commission, which deals with issues to do with corruption. And finally, on the proceeds of crime, we have a law which is called Criminal Evidence Act, and a law on the proceeds of crime. So I hope and trust that when in actually mopping this particular proposal, the talk is to take into account the already existing structures within the national countries, so that they get to play, and there is some kind of network, so that we are necessarily not bogging down, or we are putting too much pressure on the Ministry of Finance alone. So a netball or a football team plays together so that they accomplish one goal. Thank you.
Thank you, Zimbabwe. Next is Namibia. And thereafter, I also saw a hand from Tanzania. Tanzania will come immediately after Namibia.
Yes,
Namibia?
thank you very much. I want to address myself to section 119 and 120, the penalties. Firstly, maybe it's a point of clarity from the doctor as to what we intend to actually create. Do we intend to create a rebuttable presumption, or do we intend to create a strict liability? The reason why I ask that is this: if we do then intend to create a strict liability offense, then we should go the distance. Not only should we go the distance, but by going the distance, I mean, you must then remove the defense to say that if you've contravened, you've contravened. But you don't just go the distance with saying that. You must actually then take your offenses and cluster them in a level of gravity, to say that if you have contravened these particular sections of the regulations or an act relating to this model law, then you are liable. If you have committed these, you are required to have, or you are presumed to have the requisite mens rea, unless you show that you actually didn't. In fact, I use the word show very, very loosely, because in some jurisdictions there is a presumption of innocence. So the rebuttable presumption of guilt only goes as far as you saying that, look, I did not have the knowledge. Then the owner stands back on the stage to show that you actually had the intention or the requisite mental element to that particular offense. So just as a point of clarity, what is it that we seek to create? Is it a strict liability? If it is strict liability, then we must go the distance, but then we must separate the offenses, because there are some offenses that would be easier to prove mens rea if it exists. There are others that, as he says and rightly says, that you simply just find quite impossible. And with those, I think the defense should completely go away, and rather you deal with that at the point of meting out the necessary punishment. What I mean by that is, if, for instance, you might have a person who has committed an offense unknowingly, or reasonably could not have possibly known, but nonetheless, an offense have been committed. And if it's a strict liability offense, the adjudicating officer or the judicial officer would then be able to look at that and say, well, while you've committed the offense, You should have had better knowledge, but I'm not going to make out the maximum sentence. That's one. Two, if you create a strict liability offense, or if you create strict liability offenses blanketly on the whole law, you would have a situation of a junior officer who knew that an offense was being committed, but at that point in time was acting under extreme duress of his authority. He knew an offense is being committed, he committed an offense, but there's another defense, and that is I was acting under duress, or I was acting under authority. What then happens to that person? Do you convict him because simply he did the act and he had the intent? What about all the other defenses? So I think when we say strict liability, it must be strict liability, but then we must be specific as to the offenses to which that strict liability applies. Thank you very much.
Thank you. Namibia now, Tanzania.
Thank
And
you.
thereafter, I will allow the legal drafter to respond after Tanzania.
Thank you. My name is Zedi from Tanzania. I'll be not far from the previous speaker from Namibia. We understand that there's a general legal principle that ignorance of the law is not a defense. So if you go to propose clause 119, subsection 2, it says that it is a defense for a person charged with the offense under this section in respect of provision of these acts or regulation under this act to show that the person, then it goes with that. Then if you go to 119 subsection 2B, it says that it is a defense for a person who did not know and could not know reasonably have been expected to know about the failure of the comply. So don't you see a contradiction? If we say that ignorance of the law is not a defense, but again, we are putting a clause which says it's a defense for a person who did not know, then because everybody will use this as an exit, because it's there that if you don't know, then it's a defense for you. So I propose that this clause which says it's a defense for a person who has done a certain financial misconduct should not be there at all. That's my proposal.
Thank you. Dr. Greenberg, we have interventions from about 6 honorable members.
In relation to the comments from the honourable member from Eswatini, he questions the language of 1192 is a defence, and I confirm that that is normal legislative language. It creates as a matter of statutory creation in the same way that 1191 says it is an offence, 1192 says it is a defence. That is entirely normal, and that does not give that doesn't confer any discretion on the minister, absolutely not. This is a matter for the courts to determine, and indeed the whole of Part 11 is the offences are entirely matters for the criminal prosecuting authorities and the judicial authorities, the courts, to determine liability. I will now take together the comments from the honourable member from DRC and the honourable member from Lesotho. I will take their points together. How much can Parliament do if ministers are behave criminally? Well, nothing. If ministers behave criminally and the prosecuting authorities refuse to prosecute, or the courts refuse to convict, what can Parliament do? Nothing. The criminal law isn't working. This is about public financial management. This is not about mending criminal law that is not fit for purpose. This is a model law predicated on the assumption that we are dealing with SADC member states who are rule of law countries with independent prosecuting authorities. Where that breaks down, that is a problem in relation to the criminal law. Parliament cannot become a court. There is a separation of powers issue that is enshrined in the constitution of every SADC member state. And if I may just briefly move the suggestion from the honourable member from Zimbabwe, there's a point at which Parliament must take over. No, that's wrong in terms of separation of powers. That's not how we work. Parliament doesn't take over the job of the prosecuting authorities. If it's a criminal offence, then it is for the prosecuting authorities to enforce it in accordance with the separation of powers. The parliamentary, what we've done in clause 121 is go as far as possible. I respond to the honourable members from DRC and from Lesotho. We've gone as far as possible in the direction of giving Parliament influence in this area. We've allowed reports of the Auditor General and the Public Accounts Committee, a parliamentary official and a parliamentary committee. We've allowed them to publicly identify public officials for having failed to discharge functions under the Act or for having behaved with financial impropriety. That's a very big step in the direction of what those two honourable members are asking, but it's in accordance with the separation of powers, and it doesn't give Parliament the right to adjudge criminal offences, which would be contrary to principle. As to what the honourable member said from Lesotho said, what if the police don't act? I agree, it's a huge problem, but it's not a problem that can be solved by a provision of the model law, which is predicated on the assumption that prosecuting authorities, that the police will investigate and the prosecutors will prosecute. The honourable member from Zimbabwe, in relation to clause 122, raised the question of other ministries already or other components of the state or other agencies already involved. I agree with what she says, and I respectfully agree that that will be a contextualization issue. She asked about corruption as well as bribery, and insofar as she might be suggesting mentioning corruption expressly in 1222A alongside bribery, I think, if I may say so, I think that's a very good idea, and I propose to make that change unless I hear any objections from other members. Her point about Parliament taking over, I've already addressed. In response to the honourable member from Namibia, and again, I think this is something on which it would have been quite helpful to have a discussion in the margins, which I'm unable to do. But look, we've got to be very clear here. He says, are we creating strict liability or rebuttable presumptions? Well, it's very clear what we're creating. We're creating strict liability offences, which are very normal. And yes, a rebuttable presumption arises for a defence in relation to a strict liability offence. That's how they work. You say, this is the offence, and if a person can show a complete lack of culpability, can prove it, then they are not guilty of the offence, or they have a defence which knocks it back out of the park. The suggestion that we should make these offences strict liability without any defence at all, and simply divide it by reference to different provisions of the regulations is not one that I could sign up to. And you would have to have the Attorney General of every single SADC state confirm that despite the rule of law provisions and the separation of powers, they were content with that provision. And I do not believe you would get that. And I certainly would not be able to draft a provision of that kind. It is not in accordance with rule of law understanding. When you have a breadth of strict liability offences of this kind, to have genuinely innocent officials in the kind, as was described by the honourable member for Lesotho, to have genuinely innocent officials depending purely on mitigation, as the honourable member for Namibia said, well, we won't punish them very much. You can't do that because they've still got a criminal record. And we cannot have people thrown on the mercy of the judges not to punish them very much when they didn't do anything wrong in the first place. So I have severe difficulties as a rule of law drafter with that suggestion. However, and as I say, I would not be able to do that, and you'd have to go to your attorneys general and your implementation process, and the attorney general would have to allow you to do that, and I find it hard to believe that they would do that. However, I think there may be a misunderstanding here. Having a rebuttable, what the honourable member for Namibia referred to as a rebuttable presumption, having that in relation to a defence is not a free exit pass. The honourable member from Tanzania said everyone will use it as an exit. Well, that just doesn't do justice, if I may say so, to the way the criminal law works. If you look at clause 1192B, the person has to show, has to prove, yeah, in accordance with, show means prove here. We use the word show because, as the honourable member for Namibia said, this is a rebuttable presumption coming in at the point of a defence to a strict liability offence. They have to prove, and in general, most jurisdictions will have a separate burden of proof for this. It's a matter of your criminal laws, yeah. They will have to prove that they didn't know. That's quite a serious threshold. And not only do they have to prove they didn't know, they have to prove that they couldn't have been expected to know. That's a very high threshold. So I say to the honourable member for Tanzania, who says everyone will use that as an exit, no, they won't, because that's not what the provision says. They will only use it as an exit if they are capable of proving to a court in accordance with the standard of proof, not only that they did not know, but that they could not have known. That is a significant threshold. It is not an exit for anybody to use. And I think that misunderstanding, if I may say so, may flow through to the remarks of the honourable member for Namibia in the closing remarks that he made, where he referred to the presumption of innocence. And I remind him that the presumption of innocence it operates just as strongly in relation to a strict liability offence as in relation to any other. Of course it does. What the difference is, what is required to rebut that presumption. Yeah. Similarly, the honourable member for Tanzania said that having a defence to a strict liability offence contradicts the concept of ignorance of the law not being a defence. No, it doesn't. Ignorance of the law not being a defence is a general, not being an excuse, is a general proposition about the criminal law. And that survives as a general principle in relation to criminal offences of the kind that we're creating. So it will apply, for example, in connection with the offence under section 120B2B, which is not a strict liability offence, and the ignorance of the law not being a defence will continue to apply then. But when you make a strict liability offence, for the reasons I've given, it's necessary to ensure that people who are genuinely non-culpable and are not within the area that the law intends to punish have a way of proving their innocence, and they do that in part by showing not just ignorance, but that they couldn't have been expected to know, and that is a very standard feature of the criminal law and is entirely consistent with the presumption of innocence and consistent with the general proposition that as a matter of general criminal law, ignorance of the law is not an excuse.
Thanks so much, Doctor, for the responses. I see other hands from Namibia on the side. Yes, Namibia. Then thereafter, we may proceed after the doctor has responded.
Yes, thank you very much. I indeed agree with the doctor that I think some of these aspects are aspects that one should really have a direct engagement with a drafter for one to understand the depth of everything that he says, and two, for him to be able to gauge what we are saying in reality, because you can't really have a dialogue in this fashion. But having said that, I just want to return to one aspect that I've mentioned, and he didn't comment on that. And it is, he's addressing mens rea as intent, direct and indirect. But what about a person who actually knew that an offense was being committed? This is the example that I used, but is acting under duress. If you are creating a strict liability for which intent is, or the lack of intent is a defense. What about all other mental elements? I did not necessarily want to commit an offense, but I knew an offense was being committed. But I was afraid a minister is saying to me, pay that person, or X person is occasioning X threat on, I suppose in some countries, my loved one. That person knows that an offense is being created, knows that whistleblowing will have a dire consequence on myself and perhaps loved ones. So I am just going to do it and hope that I will not be caught. All I'm saying is, the moment you create that avenue, the defenses will not end. They will be endless. So I was sort of opening another avenue to say that maybe there would be a need to cluster your offenses at the level of gravity. These sort of offenses fall under this, and these others fall under this. Maybe he can just comment on that and share his view on that, because I think you omitted to say something about that. Thank you.
Thank you. Over to you, Doctor. After you respond to Namibia, then we proceed with the rest of the section.
So, three comments in response to the observations of the honourable member from Namibia. First, the effect of duress in relation to offences will be decided by each jurisdiction's general criminal law. And again, it's not for the Public Financial Management Code to interfere with the each jurisdiction's law on duress. What I would say to him, though, my second comment is, what I would say to him is that, of course, the model law is expanding the notion of personal responsibility. And some of the scenarios that he mentioned, you know, my senior officer has ordered me to do it, we're taking out of the realm of the standard criminal law on duress in each jurisdiction and making it a personal responsibility under the Act by making it a criminal offence that each public official potentially commits. So that would be my answer to him on that. Classification of offences, no, because the truth is the gravity doesn't depend on which section you didn't comply with. The gravity depends on the circumstances surrounding it. There is no one provision of the Act that we could point to and say breach of that is always trivial or breach of that is always serious. Everything will depend on the circumstances. And so what I say to him about that is that, again, the classification of offences is by reference to the desire to ensure a balance between evidential burden being reasonable and ensuring that people who are not culpable are not punished. In terms of the seriousness of offences, he referred earlier to the role of mitigation, and that is important. As I said, it's not a get-out clause, because a mitigation, you're still stuck with a criminal offence, but it is relevant to gravity, as he says now. it's a relevant proposition. So it comes in at that level, as does prosecutorial discretion. You know, prosecutorial discretion has to be factored in here. And in each jurisdiction, I would expect that gravity is relevant to how prosecutors exercise their discretion, but not trying to lump all breaches of this clause as serious and all breaches of that clause as trivial, because I think that if you do that, you will find that a lot of very serious behavior gets swept under as a trivial misdemeanor, and that would run contrary to the personal responsibility impetus of the model law. I think that's the best I can do by way of responding to those comments.
Honorable members, we proceed with the presentations. Doctor, let's move on. Doctor, would you unmute yourself?
Oh, yes,
Thank you.
yes. Yeah, well, I don't know, you might have preferred not to hear some of that, I don't know. But I move now to part 12 on cryptocurrencies, and here we have a problem. The technical working group asked me to introduce a significantly expanded set of rules about cryptocurrency. And I have done that. I have brought in a whole part. The slight problem is you don't know what to say about cryptocurrency because it's changing every second, never mind every month or every year. The role of cryptocurrency is changing all the time. At the moment, central banks are considering whether to issue their own cryptocurrencies. Those who don't want to issue their own cryptocurrencies will still be exposed to cryptocurrency in some way or another, whether it be in relation to contracts, procurement contracts, whether it be in relation to government debt, whether it be in relation to securities exchanged on lending. Yeah, there's it's just everywhere now. So we can't say nothing about it, but we don't know what to say about it. So that's a little bit of a problem. So what we've done is as follows. We have the first thing we've done in clause 125 is we have defined the class. And this is difficult to do, but we've tried to define it in a generic way, referring to cryptography as the core asset distinguishing feature. Then in 126, we have laid down some regulatory principles. And in doing that, we have drawn on international studies that have tried to articulate timeless regulatory principles in relation to crypto assets and cryptocurrencies. Constructive engagement for the orderly integration of the crypto assets into existing financial arrangements, functional classification, consumer protection and investor protection, cryptographic technological understanding, and constancy as a benchmark for cryptocurrency integration and indeed regulation. So we have identified those regulatory principles and we have required those to be taken into account by public authorities in the exercise of their functions. We're not regulating cryptocurrency. Let's be very, very clear. We're not regulating cryptocurrency in this act, and that's not the purpose of the model law. That will be dealt with by central banks and by financial regulatory authorities. It is no part of the public financial management model law to try to regulate cryptocurrencies. But we have to reflect in the public financial management context what regulatory arrangements may be developed in relation to them. In clause 127, we also require ministers to include cryptocurrency wherever practicable. That will be, for example, in accounting arrangements. Yeah, you mustn't leave them out of your accounting. If you're doing whole of government accounts, you mustn't just ignore crypto assets. You may not like them, but you can't ignore them. We also require, in clause 128, the government, the executive, to maintain a virtual currency strategy, again, only in the public financial management context. And in the same context, we allow, in clause 129, the minister to give guidance about the way in which cryptocurrency is approached for public commercial transactions. I stress that in contextualizing the implementation of clause 129, governments will have to give particular care, particular attention to overlap with existing financial conduct, financial regulation, financial transactory regulations, and they will have to avoid any overlap between those and the model law.
I'm sure the doctor is ready to take interventions from honorable members on part 12 of his presentation. You can see behind there, which country? Eswatini. We have Eswatini, South Africa, Zambia, I think these are the three. Yeah, South Africa, yes, I've mentioned. So we have Eswatini, South Africa, and Zambia in that order. Eswatini, please.
Thank you. My name is Mduduz Matsebula. My question or intervention is on the part 12, digital currency. We appreciate the regulatory principles and guidance, but as we reflect and consult and deliberate on the PFM model law, we were hoping to be guided on the use of cryptocurrency for public commercial transactions, including the use of crypto as legal tender, integration of crypto assets into the existing financial arrangements, and protection of clients. Somehow I thought as SADC we were going to take a position on this issue so that we can use it as a benchmark. But in the absence of one, I would appreciate to know if we have a member state that has a virtual currency strategy or policy that perhaps we could consult. Thank you.
Thanks. That's what in now South Africa.
Thank you very much, moderator and Doc. It's very interesting. I was waiting for this part 12 as well. And I am very glad that you mentioned that you are not intending to regulate, put regulations on this cryptocurrencies, because in many countries it's not clear, even in our individual countries. We don't know the position of it. We know that some individuals, they just choose to trade, like here in this country, the very famous one is through Bitcoin, whereby I can just go to use my gadget and trade without the country. So now, as much as I understand you that you are just laying principles, and then one of your principles is to say that the specific regulatory, in terms of the principle, one of them, section 3A, must be constructive engagement, which is, I think is very needed in order for us as citizens of each countries to understand within our jurisdictions of countries. And then you also mentioned that the central bank will take that one forward. And also, I think that also, as I'm mentioning that here in South Africa, the famous one, it's a Bitcoin. So I was wondering in terms of paying tax or tax issues, how other countries are going to have a capacity to manage each and every individual who embark on this trading. And I think I agree with you that no, we can't just ignore it. It's happening everywhere, whether we like it or not, it's happening. So we must have some sort of regulation. But again, if I can just check with you, how is our approach going forward? Because we are expected to have this model law as soon as possible. With those things that you mentioned, that no, you can't just take a decision now, but you were advised by your technical team that no, let us say something about this because it's taking place whether we like it or not. Thank you very much.
Thanks, South Africa. Now we go to Zambia.
Thank you so much. I would like to draw your attention to clause 128 and 129. That is virtual currency strategy and virtual currency guidance respectively. So I will start with 129. 129.3, where it says that before issuing guidance under this section, the minister shall consult the accountant general and the auditor general. Okay, which is okay. I think this is fine. Then we come to, I would like to take you back now to 128. Where it says the minister shall publish and maintain a strategy. That is the virtual currency strategy. Now, I was thinking, when you look at the two, I feel that a strategy comes before you provide guidance. First, you need to develop a strategy. Then as you are implementing what is in the strategy, okay, that's when you will be providing that guidance to the people you need to give that guidance. So I wanted to suggest that can it be okay if the development of the strategy, during the development of the strategy, the minister can seek consultation from the accountant general and the auditor general as well at the time of developing the strategy, so that they are not just consulted during the time when the minister is giving guidance. That's number one. Then number two is that if that can be agreed to, then I don't know if it can be any harmful to edit what is written in 28, where it says the minister shall publish and maintain a strategy. We edit it to include the minister shall develop, publish, and maintain, so that we include the words develop, publish, and maintain. Then we also indicate that in consultation with the accountant general and the auditor general. Thank you so much.
Thank you so much. I also see a hand from Tanzania on the same. Do you have the floor?
Yes, sir. Thank you very much. I'm just on the same issue of consultation, as it is written there. Before issuing guidance and under this section, the minister shall consult A, the accountant general, B, the auditor general. I propose we put a clause, we had a clause C, the central bank. And why do I mention the central bank here? The minister is given powers to guide on the issue issues under the related to the mandate of the central bank, that is issuance of legal tender, national payment system, and banker to the government, consulting the central bank will ensure that the critical role of the central bank are not impaired by the ministers' guidance, and independence of the central bank is protected. I believe in our region, every country has its own central bank. And as all of you know about the big bank, is the bank or the regulator of all the commercial banks. Now we are making a law here. We are only mentioning the accountant general and the auditor general. But when we talk of tender, the legal exchange, say currency and what, well, I think central banks should be mentioned here. I submit.
Thank you. I also see a hand from Angola. I think I'll give you the floor, Angola, before we allow the legal drafter to respond.
Muito obrigada. Eu, sobre essa questão das criptomoedas, eu queria emitir a seguinte opinião. Esta é uma variável nova nas finanças públicas dos nossos países. Mesmo os países que já têm o uso das criptomoedas, não é uma matéria que está regulada, é uma matéria nova. Daí que me parece que a lei modelo, e como já foi dito aqui por alguns colegas, devia de facto trazer elementos que até pudessem ser usados de formas a que não passemos a usar as criptomoedas e depois mais lá à frente virmos a ter problemas. Então me parece que de facto há aqui já algumas pistas naquilo que tem aqui na parte 12, mas é aquilo que deve haver aqui normas concretas de como nós devemos aderir às criptomoedas. Por outro lado, isso é uma questão que em off já tivemos a abordar. Há aqui uma outra questão que eu também gostaria de abordar. Sugerir até que os nossos redatores, pelo menos 1 ou 2 técnicos ligados à redação da lei modelo, visitassem os nossos países, alguns dos nossos países, antes de fecharem essa lei. Eu estou a sugerir visitar, por exemplo, Angola, que é uma realidade que, de facto, muitas pessoas não conhecem, né? Porque durante muito tempo, e aqui, em algumas reuniões da SADC, fomos até, algumas pessoas diziam que os dados da Angola nunca eram conhecidos, as pessoas não conhecem. Então, talvez fosse bom ir ouvir algumas instituições, o Ministério das Finanças, o Tribunal de Contas, já que nós não temos a figura do auditor-chefe como tem os outros países, mas temos o Tribunal de Contas, o próprio Parlamento. Eu acho que isso iria ajudar bastante. O caso, eu digo isso, e não seria só para Angola, mas ouvir alguns países, tirar uma amostragem de alguns países e ouvir também alguns países antes do fecho da lei modelo. Portanto, eram essas, sobre essa parte 12, eram essas as minhas considerações. Portanto, a lei deve ser clara em relação às normas que está a sugerir sobre o uso de criptomoedas, quem deve autorizar, qual é o papel do Banco Central, qual é o papel do Ministério das Finanças, qual é o papel do próprio Executivo, tendo em conta até o tipo de governo que cada um dos nossos países tem. Portanto, ter tudo isso, ter ter tudo isso em conta e depois então poder criar normas aqui na lei modelo que nos possam de facto ajudar a usarmos as criptomoedas com alguma segurança. Muito obrigada.
Thank you very much, Angola. Now let us allow the doctor to respond to the interventions from Eswatini, South Africa, Zambia, Tanzania, and Angola. Over to you, doctor.
In relation to the comment of the honourable member from Eswatini, I agree that guidance on the use of cryptocurrencies will be developed as legislation goes forward. As he says, not something for the face of the model law, but something that needs to be developed generally. As to the question as to whether there are useful strategies already developed in any SADC member state, I'm afraid I don't know the answer to that, but I have no doubt that honourable members present from other states that do have such a strategy will let the honourable member for Eswatini know. In relation to the comments of the honourable member from South Africa, I respectfully agree with her comments in relation to the lack of clarity going forward as to how cryptocurrencies will play in the markets. I agree with her observation on clause 126, subsection 3A. And as I said to the honourable member from Eswatini, I say to her too, in response to her questions, how do we go forward? And that is that additional quasi-legislation, regulatory legislation, subordinate legislation will be developed under the model law, but also for non-public financial management purposes under financial regulatory law that exists in each jurisdiction. The honourable member for Zambia suggested adding the consultation requirements from clause 129 to clause 128. If I may say so to him respectfully, that sounds like an excellent idea to me, and I will adopt it unless I hear to the contrary from any other members. The honourable member from Tanzania suggested adding central banks to the list of consultees in clause 1293. If I may say to her respectfully, that sounds to me like an excellent idea, and I will adopt it unless I hear to the contrary from any other honourable members. In response to the honourable member for Angola, the Public Financial Management Act cannot regulate non-public aspects of cryptocurrency usage. That is outside the scope of the Public Financial Management Act. However, as the honourable member for South Africa said, we've gone as far as we can by developing general principles that will be applied across the regulatory board. And that goes as far as we can without, of course, interfering with the sovereignty of each SADC member state to develop their own cryptocurrency regulation policies in accordance with their consumer and other banking laws in due course. The honourable member for Angola makes, if I may say so, a very profound point about the difficulty of legislating at a regional level for jurisdictions that have such very different circumstances. And the point that he makes about not having an auditor general in the same form as other jurisdictions, it's a point he made yesterday, as did the honourable member from Mozambique. And I think it's a very important point, very profound. And you know, there isn't, he doesn't suggest there's an obvious answer, and there isn't an obvious answer. We've tried, particularly in part 12, to legislate at a principle level, partly to give maximum flexibility for contextualization in the circumstances of each country. But his point is a profound one, and it's something we just need to take very seriously as we develop model laws and give guidance in the preambles to the model law as to their implementation strategy and contextualization. And so far as I believe the honourable member for Angola included in his remarks a personal invitation for me to visit the delightful country of Angola, and I accept that invitation with alacrity. I shall look forward to being there.
Any more intervention on part 12, or we move on now? Can we move on? Yes, Doctor, let's move on after part 12.
I take parts 13 to 15 together and I'll take part 16 at the same time. State governments, local authorities, and state-owned enterprises. State-owned enterprises were mentioned yesterday in particular. The issue here is very straightforward. Different jurisdictions have different relationships between state governments and the federal level. Local authorities in some places are major financial management powers, in some places they're less so. And state-owned enterprises are, to put it bluntly, potential ways of undermining the controls of public financial management if they are allowed to proliferate without regulation. However, the circumstances of state governments are different from the circumstances of federal governments. The mechanisms and structures of local authorities are different from the mechanisms and structures of central ministries. And state-owned enterprises is an open class that has an open range of possible variations of structure and mechanism. So what do? Do we leave them out? No, we can't, because they would undermine the controls. Do we put them in? Well, we can't, because we can't say everything we need to about them. So what we do is we have 3 schedules, one for state governments, one for local authorities, and one for state-owned enterprises. In parts 13, 14, and 15, their clauses and their associated schedules. And what each jurisdiction does at the implementation phase is it articulates which aspects of those 3 kinds of entity require to be controlled in accordance with the model law, and what variations are required in order to make sense of those of application to those entities of the provisions of the model law. For example, how do you map the finance ministry obligations in relation to state-owned enterprise? Who's the accounting officer? What's the relationship with the PAC? You set all that out in the provisions under the schedule. Not subordinate legislation, because then that's wholly within the gift of the Minister of the Executive, and as has been said by a number of honourable members, that is undesirable, so it's done in the schedules, and then it will be part of the primary legislation. Part 16 is the standard final provisions that one would expect to find, and I draw attention only to clauses 141 and 142, general regulation relation powers with parliamentary scrutiny, and also the 140, 140 guidance, again, with parliamentary scrutiny expressly provided for. That brings me to the end of those parts and to the end of the model law.
Another big hand of applause for that. Thank you so much. Thank you so much. Thanks so much, Doctor, for that. Are there any interventions at this stage? Yes, I can see the country. That's Lesotho.
Yeah.
Yeah, okay. There's Lesotho in the other hand. There's Zimbabwe. Which other hand? There are only 2 hands at the moment. Zambia. 3. Lesotho, Zimbabwe, and Zambia.
Thank you, Mr. Moderator. Could you please allow me to read section 137? My question will be based on that section. 137 says this section applies where the minister or another person is obliged under or by virtue of this act to lay a document before Parliament. The minister or other person shall also, as soon as is reasonably practicable, publish the document, A, on the ministry's website, and B, in such other ways as the minister or other person thinks appropriate, subject to subsection 3. 3, the minister may make regulations about the timing and form of publication in accordance with the section. So my question is, does this clause cater for publication of procurement results? We will also wish to have that explicitly stated in the procurement section in 101. Thank you.
Thank you, Lesotho. We go to Zimbabwe.
Thank you, moderator. I am taking the podium on the discussion on the model law for the final input. Normally, I don't approve of documents easily, but I want to thank the doctor for this for part 13, 14, and 15. Why do I say that? I say that you will find that the illicit financial flows normally occur in local authorities. The assets, etc., abuse of resources, which are supposed to be targeting for service delivery, are lost in state-owned enterprises or parastatals. And by the very mention and provisions that the professor and his team have put in this document, something that we can rely on in terms of curbing the IFFs in our various countries. And I want to congratulate you, Doc, for these provisions and to appreciate the work that we have done in this particular model law. Thank you very much.
Thank you. Zambia.
Thank you, Doc, and congratulations on the excellent work that was done on this document. On the part that you're just from presenting, I do not have any issues with them. I wanted to ask if I can maybe just take you back a little bit to some issues that we have already done, because I thought we can just take advantage of the concluding part. It is not very contentious. Only clause 107, subsection 7, it says the accounting officer of a ministry shall be responsible for the preparation of the ministry's resource accounts and their transmission to the Auditor General. So number one, because I have two issues. So number one is on the issue of transmission to the Auditor General. I've been thinking, because this principal officer who is being referred to as accounting officer, when they prepare the accounts, I don't think they are the ones who send to the Auditor General. They submit whatever they have to submit to the Accountant General, who then prepares the documents that are reviewed by the Auditor General. So I wanted to ask if you can just enlighten me on why we talked about transmission to the Auditor General instead of maybe transmission to the Accountant General. The number two is on the terminology of accounting officer. I know that it has been explained who constitutes an accounting officer. That is, I think, under 21. So I wanted to ask, why don't we use a terminology like controlling officer? Because sometimes using accounting officer, it's like we are referring to the people who do actual accounting. And when you go to most countries, when they say that this one is an accounting officer, such an officer is actually required to be a member of the regulatory institution or regulatory institute, a regulatory authority in that particular country. So why don't we use a terminology like controlling officer, because it's not just accounting issues that they are responsible for. They are also responsible for procurement as well. Thank you so much, Doc.
Thanks so much, Zambia. I'm not seeing any hand anymore. Doc? I can say Eswatini is also itching to raise a point. Eswatini? Oh, that's Lesotho. That's Lesotho. Lesotho, then Namibia and Mauritius. Oh, that's Madagascar. Yeah, sure. Sorry for that. So we have Lesotho, Namibia. Oh, that's DRC. Okay, Lesotho, DRC, and the Mauritius. Lesotho first.
Thank you, Mr. Moderator. My question is on part 15, section 134, 5 in brackets. It's under state-owned enterprises. Even though, Mr. Moderator, I'm not sure if this is the right section to put my question, but let me just put my question. The question is, how do we align this section with regulatory aspects of control by the state on its share? For an example, how do we link procurement quota with government share? Mr. Moderator, I thank you.
Thank you. That was the Lesotho. We move on to DRC.
Merci beaucoup pour la parole. Je voudrais remercier à mon tour le rédacteur de la loi type sous examen. Compte tenu des débats que nous avions eus dans la salle, compte tenu des préoccupations de chaque pays, je me rends finalement compte qu'il est difficile d'appeler ça une loi type. D'autant plus que la loi type s'est basée uniquement sur les principes fondamentaux de gestion. Nous aurions pu intituler ça autrement pour permettre à chaque pays de se référer à tous ces fondamentaux pour élaborer une loi type qui se réfère à tous les fondamentaux de la gestion qui ont été évoqués tout au long de l'exposé de notre expert. Il a ramassé pratiquement tous les fondamentaux liés à la gestion d'une république, liés à la gestion des finances publiques. Et donc, ce sont ces fondamentaux qui vont aider chaque pays respectif à pouvoir rédiger une loi qui est adaptée au fait aux réalités de son pays. Nous voudrions ici aussi remercier la SADC qui a pensé avoir un expert, parce qu'en fait, le souci de la SADC est que chaque pays puisse avoir une gestion orthodoxe en ce qui concerne la gestion publique. Donc, c'est ici l'occasion aussi de remercier en fait la SADC par rapport à ça. Voilà ma petite intervention. Comme on est arrivé à la fin de la loi, parce qu'on se réfère notamment à tous les fondamentaux, la gestion de la chose publique, la passation des marchés. Donc, tout ça, ça fait partie des fondamentaux d'une gestion de la chose publique. Merci beaucoup.
Thank you, DRC. Mauritius now?
Madagascar.
Oh, Madagascar. Sorry, my apologies. Madagascar, please.
Merci, monsieur le modérateur. Je voudrais aussi remercier à notre rédacteur juridique et surtout son explication détail par détail. Merci beaucoup. Mais je voudrais vous demander, je ne sais pas si c'est une demande ou solution, parce que chaque fois, nous, les parlements malagasy, on vote chaque année, 2 fois chaque année, la loi de finances. L'autre fin d'année, chaque fin d'année, on vote les lois initiales. Et le mois de mai, et là, ça va commencer le 3 mai, notre réunion, ouverture officielle, première réunion pour et les faire, c'est-à-dire les lois de finances rectificatives. Donc, je voulais juste dire que est-ce que c'est pas logique si c'est avant d'élaborer la loi de finances, les ministères devraient passer devant l'Assemblée nationale ou les parlements pour demander les besoins chaque district pour mettre déjà dans la loi de finances pour faciliter les suivis et les contrôles des députés après avoir après avoir finalisé la loi de finances pour voir que est-ce que vous avez déjà fait cette infrastructure ou comment vous avez fait l'argent. Chaque district devrait donner leurs propositions de leurs priorités pour faciliter les suivis. Je ne sais pas si c'est demande ça ou c'est la solution, mais il y a des pays qui a déjà les systèmes là. Donc, je ne sais pas comment on va faire. Je pose cette question avec vous, monsieur le rédacteur juridique. Merci beaucoup.
Thank you so much, Madagascar. I think those were the hands that I had. I'm seeing now a fresh hand from Tanzania. Over to you, Madam.
Thank you, sir. On clause 134, subsection 4, C, the state-owned enterprises. On C, it reads, provided that a body listed in Part 1 of Schedule 1 is to be treated as state-owned enterprise for the purpose of the application of this act only. Now, here my comment is, the clause maybe we should add Part 4 without contravening the law that established a body. I'm saying so because just to justify, to avoid conflicting laws in situation that the reason to add a body in Schedule 1 is contrasting clause in establishing law for central bank. This clause will ensure that the establishing, I was trying to draft laws at the central banks guarantees the intended independence. Now, if doctor allows, or I don't know if it is the SG, after passing this here or before, our central banks, I would suggest that they meet, have a meeting, since this is something which is within, which is happening. I would suggest that they meet, they get a possibility of having a meeting together somewhere at a certain point within the SADC region state, so that they will all agree to what we are going to embark on, or what we are going to start now. That is what I was thinking loud. I hope the doctor over there, the guru of the law, will understand what I'm trying, because I know he's thinking ahead. Even before I speak, he knows what I'm going to say. Thank you.
Thank you, Tanzania. Doctor, before you come, I have received a note from an honorable member from Eswatini. He or she, I'm not sure whether it's he or she, said there's a question that he did not respond. I think he was paused to say, do we have a member state that has virtual currency strategy or policy? I'm sure that's the question, I think, from an honorable member from Eswatini.
Não estão. Era só para informar que não há tradução do português. Já
There's
há
no
uns
translation?
minutos. Don't translate Portuguese.
Sorry.
The interpreters are on. Maybe let's check.
Let's
Is
check.
it only-
Angola, you're on the Portuguese. What channel is Portuguese? Check if you are on 3. You are on 3, and there's nothing. They are sorting out. Okay. So they may, I think they have missed. We'll wait for the signal. If it is sorted out, you let us know. Hello, can you check? Can you check Angola? Mozambique, Angola, can you check? Is it okay? Yeah, okay, fine. Thank you so much. I think we are back. I was saying that before the doctor comes to respond to the interventions from the members that rose it, DRC, Lesotho, Madagascar, and Tanzania, there's a follow-up question that I have received from the honorable member from Eswatini. It says that the member posed the question, but the doctor did not respond. The question is, do we have a member state that has a virtual currency strategy or policy so far within the SADC region? I think that's a question from Eswatini, one of the members.
I did respond. I said, I don't know.
So the honorable member, I think, missed the response.
Yeah, I don't know. And I'm hoping that whichever member state does have a strategy will identify itself to the honorable member for Eswatini.
Okay. Thank you so much. Now you can respond to the other interventions that were made by the other honorable members.
In response to the honorable member from Lesotho, the first honorable member who spoke from Lesotho, in relation to clause 137 and the publication of procurement results in accordance with clause 101, yes, I completely agree with him that if, as we discussed yesterday, if the relevant regulations there include the publication of procurement results, then yes, the provisions in 137 will apply to that. I agree with him. In relation to the honorable member from Zimbabwe, I respectfully agree with her comments about illicit financial flows in relation to local authorities, and I agree that that is the purpose of the control in part 14. In relation to the comments of the honourable member for Zambia in relation to clause 107 subsection 7, yes, I'm not at all surprised to learn that in some jurisdictions this is done through the Accountant General, and that will be a contextualization issue for transposition and domestication. I have the similar response to his suggestion about accounting officer. Personally, I would not favour moving over to controlling officer for precisely the point that he made, that, of course, the primary responsibility of the accounting officer is not to control the expenditure from a policy perspective. That is a minister's job. The accounting officer as an official has primary responsibility for process, for accounting process and responsibility. But of course, this is another contextualization issue. And if in Zambia it makes more sense to talk about controlling officers, then of course that is what they will do at the domestication process. In response to the second honourable member from Lesotho, yes, the point about government share is a very varied one. It's a very technical one that varies from situation to situation, and that, as she says, is the reason why it would be dealt with in the schedule on a case-by-case basis. In relation to the comment made by the honourable member from DRC, yes, I fully endorse and respectfully concur with her comments, and this is the contextualization process to apply the principles in practice. In response to the honourable member from Madagascar, yes, again, I agree with her respectfully that parliamentary oversight ought to work in that way. And the model law presents a number of techniques, including all the committees and the questioning processes listed in the parliamentary oversight part, and all of those should be used creatively and effectively. In relation to the comment from the honourable member from Tanzania, in relation to clause 1343, the words along the lines that she described would not help, because this is about an issue of contradiction between the two laws, and each state will have its own rules. What I would say to her is this: the implied repeal doctrine in each jurisdiction will apply in such a way that a general provision of a model law of this kind, when implemented, would not defeat a specific provision about the central banking law of the way that she, in the form that she describes. That would take precedence, and that is the result that I think she wants to achieve. She suggests further meetings, and that is a matter for the Secretariat. And I believe I have answered all the points. If you will permit me, Mr. Moderator, I would like to conclude with my own thanks to honourable members for the very penetrating and clear way in which they have presented challenges to the model law, and for the very helpful way in which they have been kind enough to listen to my responses. And the interaction has been penetrating and effective. We have made a number of changes to the model law. There are doubtless other matters to be discussed, And I would like to express my personal gratitude to each and every member of the Assembly for their penetrating participation.
Thank you. Before I ask the House to have another hand of applause to our doctor, there's one procedural issue that we need as a House of Records. We need to comply with, and I will perform that duty of the presiding officer. Having gone through, having proposed the amendments, which the doctor is going to work on them and refine the draft after this, I now put the question that the draft model law as inputted by the honorable members in here be refined by our learned Dr. Greenberg and be taken from here to the plenary, which will be held in Malawi from the 7th to 16th of July. Those who are in support of that, say aye.
Aye.
Perhaps those who are in contrary view with what we have done here, they should say no. There is no. So we have confidently adopted the draft model law as inputted. Oh, Angola, yes. Have the floor, Angola.
Eu estou completamente de acordo, estou no AI, mas eu ia pedir o secretariado da SADC para cuidar da tradução com alguma expertise, porque de facto nós notamos que esta versão traduzida para o português tem muitas lacunas. Portanto, estou completamente de acordo, mas esse trabalho de casa nós temos que fazê-lo, até porque nós também gostaríamos de submeter essa proposta para algumas instituições do nosso país, mas não posso fazer enquanto ela tiver essas lacunas na tradução do português. Muito obrigado. De resto, estou de acordo que ela vá para a reunião plenária da SADC. Obrigada.
Thank you so much, Angola, for those comments. Now the ayes have it, and the draft model law has been adopted by the joint committee session. Thank you so much. Now let's have a hand of applause for our Dr. Leonard Greenberg. A big hand for. Thank you so much. And the second one is a hand for ourselves as honorable members who have done a wonderful job. Another hand. Thank you so much. Thanks so much. No, thank you so much. At this stage, for the SG and the others are saying for the moderator. A big hand for the SG also and the secretariat, and including the moderator who is here. Thank you. Thank you so much, honorable members. You, honorable member, you are most welcome. You are most welcome. Thank you so much, honorable member from Tanzania, for spicing, our wrap-up session in that manner. Thank you so much. Honorable members, now it means we are now coming to the tail end of this session. And as a moderator, I will repeat what I said yesterday. I really enjoyed the interaction that we had with the honorable members. Now, I think the rest, I will leave it to the Secretary General to thank the relevant areas in the way we have conducted our business. And thereafter, I will also ask the Secretary General to request the chairperson of the Regional Parliamentary Oversight Committee to close our joint committee section. Madam SG.
Good after lunch, honorable members. Afternoon. Honorable members, allow me to stand on the protocol that has already been established when we started our proceedings. Safe to just recognize our Honorable Dr. Fiorovana Lovanirina Celestine, the SADC Parliamentary Forum Vice President, the chairpersons of our standing committees, all honorable members, ministers here present with us, staff of the SADC Parliamentary Forum, and all the colleagues, Dr. Daniel Greenbeck, who you've already recognized and appreciated, honorable members and dear colleagues, and participants from the media and other partners who are participating online. We have come to the end of this very interactive session, during which we painstakingly, proudly poured through our draft model law on public financial management. Honorable members, no amount of words can adequately capture and express my profound gratitude on behalf of the SADC PF Secretariat. Honorable members, to you all, I want to thank you for your well thought out contributions yesterday and today. I would like for you to appreciate the fact that the success of this session and many other works that the Secretariat needs to provide to you are possible because I have a very strong team of staff, of men and women, who make it very easy for me to do my work. They are very intimate with the processes that you require, and this, I pray to God, it continues until my term ends. This session, honorable members, provided an opportunity for you to seek clarification, which you did very well. You made recommendations and you shared lessons from your member states, doing something in line with what any public financial management framework requires. You have thus given further context to the finalization of the process of this public financial model law. Honorable members, just to recap, issues of translation are a human rights issue and are a constitutional matter for the SADC Parliamentary Forum. We will thus look into the translation of these documents. We've taken note that this requires technical input, not just any translation to be brought on board. We will therefore attend to this and will send the model law to Angola and Mozambique for them to assist us refine this model law further before it is actually tabled before the plenary assembly. Honorable members, we've also taken note of the fact that there's need for further engagement, in-depth engagement, because we are getting into a space that requires us to reflect on political processes, not just those that are technical. We also know the fact that the intent of the model law is to give some powers to parliaments in order to deal with issues that you have all outlined here today. It became very clear from the many comments and questions that honorable members had carefully read the draft, internalized it, and used their experience to relay to the drafter. It became very clear from the many penetrating questions, a word I've learned from the drafter, and suggestions that we all want the institution of parliament to be at the center of the development, adoption, domestication, and implementation of model laws that are developed by the SADC Parliamentary Forum. Honorable members, to us as the Secretariat, it became apparent also that we all seek a law that is cohesive, comprehensive, fit for purpose, alive to the clear separation of powers, and that this law is not unduly prescriptive, that it is persuasive, supports transparency, and is gender neutral, among others. This is the feedback that we got from yourself. I'm delighted that our legal drafter has gone to great lengths to demonstrate that this draft meets those expectations. Another round of applause. We are all further enriched and enlightened from this engagement. Honorable members, it is pleasing to note that none of the many comments and questions on the draft model law were such as to prompt major surgery on the draft that we have. That speaks volumes about the value added by the many consultative sessions and the input from the wonderful technical working groups before we met here. The working group, honorable members, is made out of your directors of budget offices in your countries. It is also made out of experts from academia, civil society, and practitioners in the area of public financial management. Nevertheless, I assure you that further to comments garnered, certain provisions of the model law will be revised in line with our discussions. We have learned drafters who are picking your comments and will ensure that we discuss this further. Where we are unable to do so, we will also be able to communicate this back to honorable members. As part of ensuring that by the time we sit for the 51st Plenary Assembly, we are all of one mind. We endeavor to bring Dr. Greenberg to Malawi for a small consultatory session on the margins of the Plenary Assembly before we get into the Assembly. I hope we'll be successful in that regard. Honorable members, the next steps will thus be adoption at the level of the Plenary Assembly. As already indicated, you'll note that the provisions of the model law have been formulated from a parliamentary perspective. And that is why it is important for us to look for opportunities where your input will be translated into the model law. We hope that as you go back to your countries, you'll also seek further input among colleagues and relevant committees so that it is indeed formulated from the point of view of oversight of Parliament, so that at the end of the day, when you seek numbers for domestication and to give a strong signal that is for Parliament to exercise oversight over the executive on public financial management, you are not alone. We understand the strength of numbers in Parliament. You have now set the ball rolling, and the model law will need your support as members of Parliament at the 51st Plenary Assembly, who may not be here with you, especially our honorable speakers, will be able to get a signal from you in terms of how far you have gone in this scrutiny. And we hope that when you go back and give reports, you'll be able to assist us in making sure that there are no departures from what has been agreed to, and that at the end of the day, any concerns are formulated and sent to the Secretariat for us to deal with these effectively. The days for the Plenary Assembly have been shared with you then the month of July. We don't count that month. May I kindly request that by the 15th of May, all submissions should be shared with us. 15th of May, all submissions, otherwise will not be accepting any submissions beyond that date. It will be frustrating for the legal drafter to incorporate any comments beyond that date. Honorable members, let me reiterate that you have produced a unique model law, which is the first document in the world. It is a baseline to lead and assist other countries in reviewing the public financial model law. We've already heard from Zimbabwe that they parked their process in order to align with what will come from this particular exercise. This cooperation between SADC parliaments and the SADC Parliamentary Forum is something that we cherish. We see this as an opportunity parallel to the development for domestication as an ongoing process to be ignited. The SADC Parliamentary Forum welcomes this particular act. We welcome you to act as emissaries of the model law and to continue empowering parliaments within and outside the SADC. ECOWAS, YALA have indicated they're interested in this model law. We'll be looking for champions among yourself to be emissaries in this regard. With these few words, honorable members, thank you for your participation. And I also thank you for recommending that this model law be recommended for adoption to the 51st Plenary Assembly. I thank you, honorable members, for your cooperation, without which the Secretariat cannot be efficient. We are now at the end, as indicated. I will now invite Honorable Leon Tumba, the chairperson of the Food, Agriculture and Natural Resources, to give us a closing and allow us to retire and spend our money in South Africa.
À l'occasion de clôture, honorable vice-président de la SADC, honorables membres de toutes les commissions permanentes du Forum parlementaire de la SADC et du Caucus régional des femmes parlementaires, Madame Bohème Segoma, secrétaire générale du Forum parlementaire de la SADC, membre du groupe de travail technique chargé d'élaborer la loi type de la SADC sur la gestion des finances publiques. Dr Daniel Greenberg, rédacteur juridique de la loi type de la SADC sur la gestion des finances publiques. Maître de cérémonie, citoyens de la SADC, suivant les débats sur les diverses plateformes de réseaux sociaux. Représentants d'organisations de la société civile, représentants des médias. Personnel des parlements et du Forum parlementaire de la SADC. Distingués participants, invités, mesdames et messieurs, c'est avec un immense plaisir que je prononce aujourd'hui devant vous cette allocution de clôture à l'issue de cette séance de validation de la loi type sur la gestion des finances publiques. Honorables membres, distingués délégués, mesdames et messieurs, au terme des 2 derniers jours durant lesquels nous avons passé au crible la loi type de la SADC sur la GFP, vous conviendrez avec moi que non seulement notre loi type représente une première à l'échelle mondiale, puisqu'elle est la seule de son espèce dans le monde, mais qu'elle constitue également un travail magistral car elle combine la simplicité et la précision requises dans un texte législatif qui aborde un sujet aussi technique que la gestion des finances publiques. Cela dit, je me dois encore d'exprimer mes remerciements au premier chef, à vous tous, honorables membres, pour votre dévouement au cours de ces 2 derniers jours durant lesquels nous avons tenu la séance de validation. Grâce à l'engagement, au sérieux, à la coopération et à la pondération dont vous avez fait preuve, nous avons été capables de délibérer dans un climat propice et de parachever même les parties de la loi qui avaient pu être considérées jusque-là comme portant sur des sujets sensibles. L'ardeur au travail et l'esprit de collaboration dont nous avons été témoins lors de cette séance de validation au cours de 2 derniers jours sont un reflet fidèle de l'intégration régionale en action. Alors que nous nous cheminons vers la présentation de la loi type pour qu'elle soit adoptée lors de la 51e Assemblée plénière, sera organisée par le Parlement du Malawi, je prie chacun d'entre vous de continuer à soutenir ce noble effort. Honorables membres, distingués délégués, mesdames et messieurs, permettez-moi aussi de rendre un hommage particulier à toutes les parties prenantes qui, malgré leur emploi de temps, ont pris le temps de participer au processus consultatif en formulant des commentaires sur la loi type. Sans citer spécifiquement telle ou telle organisation, permettez-moi simplement de mentionner que vos efforts ont fait toute la différence et que nous vous en sommes très reconnaissants au nom des citoyens de la SADC. Je félicite en outre le groupe de travail qui a supervisé l'élaboration de la loi type pour son travail assidu et l'appui technique qu'il a apporté au rédacteur. Il va sans dire que votre contribution a été inestimable. Honorables membres, distingués délégués, mesdames et messieurs, vous conviendrez avec moi que notre rédacteur en chef, le docteur Daniel Greenberg, a effectué un excellent travail eu égard à la rédaction de cette loi type. Le rédacteur a puisé dans sa grande compétence et sa riche expérience pour présenter de façon accessible et aisément compréhensible ce qui, le cas échéant, avait représenté un sujet compliqué. De surcroît, j'observe que le docteur Greenberg a agi en professionnel accompli en conciliant des points de vue divergents exprimés par les parties prenantes au fur et à mesure que la loi type était examinée au cours du processus consultatif. Grâce à lui, notre loi type est d'autant plus riche qu'elle intègre les points de vue divergents. Je suis sûr de parler au nom de chacun d'entre vous et du forum en général en disant que nous sommes redevables au rédacteur pour son temps, son dévouement et sa patience tout au long du processus. Honorables membres, distingués délégués, mesdames et messieurs, pour conclure, je rends hommage à tout notre personnel, travaillant au sein des parlements, membres et au secrétariat du forum, ainsi qu'à tous les autres héros méconnus qui ont facilité de différentes façons le processus d'élaboration de la loi type à diverses étapes. Nous vous remercions pour l'aide que vous nous avez apportée comme d'habitude. Après ces quelques observations, je déclare la séance de validation officiellement close et je vous remercie de votre attention.
Thank you, Chairperson. Honorable members, just a few announcements from the Secretariat. The first one is that for those honorable members who have not completed the attendance register for today, they are requested to do so before we leave this room. They will meet Paulina, I think she's at the back. So let's make sure that we sign off the attendance register for today. The second announcement is on the per diems. In case some honorable members who have not yet been paid their per diems, I think the secretariat is also behind our council staff at the back. Let's do so. Related to that is that for the members, the COVID test, for those who paid for it, bring the receipts with you. They will refund the receipts if you are required to pay when you are doing the PCR COVID-19 test in your countries. Bring the receipts. The accounting staff will refund. The last announcement is on the face masks. We are being advised that we have extra face masks at the back. Those members who would wish to get at least a face mask from here, they should do so. They can collect it from the secretariat at the back. Thank you so much. And lastly, the chairperson of the Regional Women's Parliamentary Caucus had asked earlier on, you remember, that all members of the Regional Women's Parliamentary Caucus should remain briefly in here before they go for a lunch. I hope that announcement still stands. Chair.
Thank you, Mr. Moderator. In view that we have finished ahead of time, may I suggest that we meet here, all the members of RWPC at 3.
Okay.
Please.
So there's a change that instead of meeting now, since we have concluded the exercise, let's go for lunch, then we come back at 3. That's what the members are objecting. They say you should meet now. So, yeah, so the members that said you should meet now.
And go and.
Okay. So, Chair, the member they said you should stand with the area announcement.
Yes, but in view that we haven't have our lunch, it would be wise for us to go and have our lunch and come back.
Yeah, but the members are saying they want to meet now before you take your lunch.
They want to skip lunch?
Yeah, that's what they're suggesting.
Do we agree to skip lunch and have our meeting and then?
Madam President.
Because it's already 1:30.
So what's the consensus?
We remain
You
for
remain.
20 minutes.
Okay.
Okay, so the
Okay.
member, they said you
It's
remain for
agreeable.
15
We
minutes
remain for
before you go
20
lunch.
minutes.
Agree.
Thank you so
Thank
much.
you.
Yes, Madagascar? Madagascar?
Merci, monsieur le modérateur. Non, je voulais juste demander, est-ce qu'il y a des moyens pour qu'on puisse visiter l'endroit historique ici en Afrique du Sud? Merci.
Okay. Madam SG would want to tackle that one.
Thank you. Are there any members who want an arrangement to visit some historical? We could quickly help you arrange for Soweto or Nelson Mandela. Is it just one? Okay, we can talk to Madagascar then about that. Okay, thank you. We'll see. Mrs. Mungandi, let's see what we can do for Madagascar. All right, thank you. Okay, it looks like we are done. The Honorable Vice President said the women can leave.